Hello and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to Conquer Prelims 2026. This is phase 4 of Conquer Prelims, where we are covering several important topics from across subjects in these one-shot marathon sessions. Today we will be covering at least 30 plus international treaties and conventions which are going to be extremely relevant for the upcoming prelims examination. If you have seen previous year question papers, you would have noticed that almost every year there are a couple of questions related to international treaties and conventions. This is a high yielding area, and if you can cover them comprehensively, you can definitely get these answers right. So today, we will discuss a number of important treaties, such as, let's say, the Rome Statute or the Geneva Conventions or the Refugee Convention. We will talk about the UN related treaties and conventions as well. So, in total, I plan to cover more than 30 topics so that there would be some guaranteed questions from what we cover today. And those of you who are asking for the final phase of Conquer Prelims, phase 5, where we will cover current affairs of this year from January to April 2026. This final phase is starting very soon. By next week, we would be launching phase 5 of Conquer Prelims. We will update you regarding the dates and the schedule. So just stay tuned for that. So before we start, I have one important announcement. And after that, we'll get started with our discussion. I want to talk to you about our Platinum program. When it comes to online classes, the biggest roadblock in an online classroom is that there is no seamless two-way interaction between a teacher and a student. This has been the main problem statement for online learners. They don't feel as motivated to pay attention in online classes, and they feel that they can't get their doubts redressed from the teachers. So that's why we have launched the Platinum program that provides for a two-way interaction where you have to keep your cameras on compulsorily so that the teacher can see the students. We can hold you accountable. We can see whether you're listening, whether you're paying attention. So this provides for a much better learning experience. And this program gives you access to all the offers that we provide as part of the online classroom program. I'm sure many of you must be aware of the Plus and Iconic offering, which mainly focuses on the online classes. But in Platinum, you get much more than that. Apart from lectures from our top educators, you will get access to a two-way interaction in every class through these Zoom sessions where you can talk to the teacher will respond back, they can hold you accountable on a day-to-day basis. And you will get access to all the study material, the test series, and more importantly, one-on-one mentorship with the teachers themselves, which is something that's not available with Plus or Iconic. So the teachers will act as your mentors. And there would be a super mentor as well, especially those already in the services who would be coming in once in a while to address the students and try to motivate them and to resolve their doubts and concerns. So this is why Platinum program is a standout course for IAS aspirants. So those interested, please check out for further details by clicking on the link provided in the video description. With this, let's get started and look at the first topic. So initially, I would like to go in a chronological order, and we'll start with the Treaty of Versailles. The Treaty of Versailles is essentially a very important topic, though it's a very old topic. It remains very relevant because of what's happening in today's world. Given the number of conflicts that are raging, given how countries have become much more averse towards conflict, and also given the fact that we live in a very uncertain world where the world order is being disrupted, the existing rules based order is being dismantled by global leaders. So as a result, topics related to this, topics related to international law, topics related to the rules based system and customary law acquires a lot of significance for this year's exam. So let's start with the Treaty of Versailles. So this treaty was signed in 1919 following the Paris Peace Settlement that brought World War I to an end. In the First World War, the conflict involving the Allied powers and the Central powers, Germany, along with the other Central Powers which were defeated, they were forced to surrender and end the conflict officially with the signing of the Treaty of Versailles and the other related treaties that were brought out under the Paris Peace Settlement. The Allied powers, led by United Kingdom, France, later joined in by US, Russia, even Italy, Japan, would be a part of the same bloc that fought against Central Powers led by Germany, along with the Ottoman Empire and the Austro-Hungarian Empire, and as well as Bulgaria. So when these Central Powers lost the war against the Allied powers, negotiations began at Paris in 1919 to work out a settlement to officially end this war. So this peace settlement process did not include the defeated powers. Defeated powers like Germany were not even consulted. They were not even on the negotiating table. So at the end of it, 5 major treaties were signed, not just one. Many students, they just know about Treaty of Versailles, but they are not aware of the other treaties that were signed. A total of 5 treaties were signed as part of the settlement process. That includes the Saint Germain Treaty, the Trianon Treaty, Neuilly Treaty, and Sèvres or Lausanne Treaty. So amongst these 5, it's the Treaty of Versailles which really stands out, because this treaty specifically applied to Germany. And the Allied powers, they tried to brand Germany as the aggressor. They placed the entire blame for the war on Germany alone. And they sought to use this settlement to humiliate Germany and to cripple Germany's ability in the future. This included demilitarization of German armed forces. It included paying of war reparations, which would crush the economy of Germany. So this humiliation that was caused to Germany would eventually become the root cause that would lay the foundation for Second World War, for the rise of the Nazi Party and Adolf Hitler. So Germany, which was not included in the negotiation process, was forced, it was compelled to accept the terms. It resulted in territorial loss for Germany. Its colonies were essentially divided amongst the Allied powers themselves. The same happened with the Ottoman Empire as well. So this set of provisions that were enforced on the Central Powers, particularly on Germany, it had a lasting effect, which eventually became one of the triggers for the Second World War. So when you look at the key provisions, Germany was made to take the blame for triggering World War I, and it included some very harsh terms. Massive reparations were to be paid by Germany to compensate for the losses, the economic losses that Europe as a continent had suffered. Up to 132 billion gold marks was set as the reparation amount, which in today's dollar price is roughly around 269 to 70 billion dollars. So this reparation was extracted primarily through gold, and Germany had to incur that financial burden in order to pay for the reparations for the Allied powers. This itself became one of the primary reasons for the collapse of the German economy in 1920s, which fueled the rise of the Nazi Party and Adolf Hitler. Because this was seen as a humiliation by these other European powers and the Allied powers. This bred resentment amongst the German people. It also divided and carved up German territory. It resulted in territorial losses for Germany. For example, the Polish corridor was carved out, with Poland breaking apart from Germany. Then even France, Belgium, and as well as Denmark, they all took control of parts of then Germany, which significantly reduced the territorial extent of the country. This led to loss of population as well. Several regions, which primarily had a German population, they were integrated into other countries. If you take Rhineland, the occupation of Rhineland, this western part of Germany was brought under the control of the Allied powers. And this also was a region that was rich in resources. So Germany suffered significant territorial loss, population loss, and loss of resources, and a big strain on its economy. But more than that, it was the humiliation which really became the trigger for the people of Germany to align with more far right-wing fascist forces throughout 1920s and 1930s. Then even German colonies and the then Ottoman territory, which is today's West Asia, they were all carved out, divided amongst the Allied powers as spoils of war. So if you take today's Levant region, which is at the heart of the current conflict which is raging, the very Palestine issue goes back to this particular development. The Ottoman territory was basically carved up between the French and the British. The Palestinian territory became a British mandate, and parts of Syria, Iraq that you see today, it came under the French mandate. So we saw the expansion of Western colonialism, where central powers were essentially given out a very harsh treatment than what they deserved. And this perceived humiliation is what triggered the people of Germany. This weakening of Germany as a nation, the hurt on the pride of the German people, is what would lay the foundation for the Second World War. So the Treaty of Versailles was largely responsible for this. It even established an international organization, the League of Nations. For the first time, a global level organization was being established to resolve disputes, to prevent conflicts, to mediate if there are wars between different countries. The idea was floated by Theodore Roosevelt, Teddy Roosevelt, and with the leadership of US and the Allied powers, the League of Nations was founded as an international organization. But the League of Nations and its failure was largely responsible for the rise of fascism in Germany and across Europe. From Italy to Germany, the failure of League of Nations was very evident. It not only failed to curb the rise of right-wing extremism, but it in a way enabled the foundation for the next World War to take place. So the League of Nations was responsible to enforce the war reparations, to extract the reparations from Germany as well. And it was entirely dominated by UK and France. UK and France dominated the League of Nations. That was a structure that was designed at the Paris Peace Settlement. So Germany had no choice. It had to accept this because it was not even brought onto the negotiating table. It was not even given a seat. And these were conditions that were imposed on Germany and the other defeated Central Powers. Now, when you look at the other key provisions of the Treaty of Versailles and the Paris Peace Settlement, countries were prohibited from entering into secret agreements. Because from late 1800s to early 1900s, the signing of such secret agreements, the formation of alliances, the formation of military clubs, is what led to animosity, hostility that paved the way for the First World War. For example, look at the Triple Entente. It was purely a security-based alliance that was formed with some of the West European powers led by UK and France. If you look at the Triple Alliance that Germany also built with Bulgaria and the Austro-Hungarian Empire, these alliances that were formed largely in secret with a clear security motive to build a security buffer against the other to create a deterrent, it triggered this race, a new sort of a geopolitical race, an arms race as well, that added to the suspicion as one side suspected the other of having territorial ambitions. So such secret agreements were prohibited through the Paris Peace Settlement and the Treaty of Versailles. But of course, none of the powers followed this. There was a arms reduction and demilitarization that was imposed on Germany. Germany's armed forces were cut in size. Its army, navy, air force. Air force was completely disbanded. And a cap was placed on the German army, and the German navy was also downsized. So this downsizing and the disarmament, it also created a further threat for Germany. Now Germany would feel not only oppressed and targeted by the Allied powers, but it would feel threatened because of its weaker military status. Then though Treaty of Versailles and Paris Peace Settlement recognized the right of self-determination, what happened was German dominated regions, German dominated areas lying next to Poland, France, Belgium, etc., they were allowed to exercise their right to self determination, carve out from Germany, and join countries like France, Poland, and Belgium and Netherlands. This loss of territory and loss of population, it further hurt the German pride. So, though League of Nations was supposed to have a universal membership and it was supposed to act as a mediating platform to prevent future wars and conflicts, it completely failed at the task because this treaty was poorly negotiated. The winners of the war basically exploited this situation to cause further humiliation to the defeated powers. And this is lesson number one in conflict resolution and conflict management. Right? One would hope that the world has learned those lessons, right? But unfortunately, contemporary geopolitics, it shows us that many powers have not really drawn those lessons from history, particularly the US under Donald Trump is almost repeating the same kind of mistakes, trying to extract maximalist demands in the negotiations with Iran, trying to humiliate the opponent, eliminating the leadership. So, this eventually adds to more resentment and creates and perpetuates fresh cycles of violence. So, though we have such lessons in history, today we have world leaders, we have major powers blatantly committing the same mistakes again. And that is what makes the world much more dangerous. So, that's why I feel these old topics can still be relevant for the exam because the rules based order itself is being dismantled over the past 2 to 3 years, starting with Russia's invasion of Ukraine and the October 7th attack by Hamas and the Gaza war and the ongoing war against Iran by US and Israel. It represents the complete collapse of the global system and the legal frameworks that were built post the war period, the Second World War period. Now, within Germany, there was strong opposition and rejection of the Treaty of Versailles. As I said, accepting the entire blame for the war was seen as unnecessary. Though Germany was indeed an aggressive power, there were other powers as well which contributed to the hostilities, including some of the Allied powers, particularly France and Britain. But they took no responsibility for World War I and they tried to blame this entirely on Germany and its allies. Then being excluded from the discussion, not even involving them in the talks, and forcing them to accept these terms is what laid the seed for the rise of right wing extremism, fascism in parts of Europe. And as you know, this would lead the world towards the next conflict. So the League of Nations was a spectacular failure. Instead of resolving the tensions, instead of addressing the standing disputes and conflicts and preventing another war, in many ways, the League of Nations and the misuse of this organization by global powers, it laid the path for the Second World War. So if you're aware of these basic facts and details, you would be able to answer any question from world history and IR. Now, let's talk about the United Nations and the UN Charter. In the previous marathon, we've already discussed the UN, its structure, its different organs and composition. We have even understood the role of different UN agencies and UN bodies. But today we'll just focus on the UN Charter that was worked out through the San Francisco Conference. At the end of the Second World War in 1945, under the leadership of F.D. Roosevelt, who proposed the idea of a United Nations to replace the League of Nations, which had become ineffective. Global powers met at San Francisco, the United Nations Conference, and it led to the drafting of the UN Charter, which would go on to become the constitution of the UN. So under the UN Charter, there are few articles, few provisions which are critically important for our exams. Especially Article 2 and Article 51 acquires lot of significance given what's happening currently. Given how Russia has blatantly violated Ukraine's sovereignty, given how Israel has attacked more than 6 countries in West Asia without facing consequences, given how US has been making territorial claims, threatening governments, trying to topple regimes. this particular topic becomes extremely important for our prelims exam. So when you look at Article 2, Clause 3, UN Charter mandates all the member states, all 193 UN member states, to resolve any standing disputes only through peaceful talks and negotiations. This is meant to uphold international peace and security. Because after the devastation caused by Second World War, the world had learnt a lesson. Finally, countries were coming together to create a more sensible world order, a rational world order, bound by legal constraints. So the goal of the UN was to avoid the mistakes of League of Nations. The purpose of the UN was to act as an international multinational organization to resolve conflicts, to try and provide a platform for peaceful talks and negotiations where mediation can occur. And without resorting to war, conflicts could be settled. That was the whole purpose of the UN. So Article 2, Clause 3 mandates UN member states to settle any standing disputes only through peaceful negotiations. And it explicitly prohibits the use of force or even the threat to use force under Article 2, Clause 4. So all UN member states are prohibited from violating the sovereignty of another country, no matter what the reason is, no matter what the justification is. Using force is prohibited under international law, under the UN Charter. Even threatening the political independence of a state is not allowed, it is prohibited. If you have seen the statements that Trump makes against, let's say, Denmark with regard to Greenland, or the statements that were made against Venezuela when Nicolas Maduro was still in power, or the statements which are being still made against Iran, issuing such threats, even showing the intent to violate the sovereignty of another country, showing the intent to interfere with another country's government, is not allowed under the UN Charter, under Article 2, Clause 4. The use of force and even the threat to use force to intimidate someone is prohibited under the UN Charter. There is, of course, one exception provided under Article 51 where countries can use force. But this applies only if it is an act of self-defense. And there is a precondition to it. There's a very high threshold which has been set to use force. This exception calls for an armed attack on a country by another state. If country A were to attack country B, and then country B can exercise the right to self-defense under Article 51 and go to war to defend itself. But only and only if there is an armed attack. Otherwise, right to self-defense cannot be invoked. So these are some important provisions that you need to note down. And under Article 51, if a country is invoking the right to self-defense during an armed attack, they need to inform the UN Security Council. They need to keep the UN briefed as to why they took this action. They need to establish with proof, with evidence, that there was an armed attack on us by a hostile power. So we are using force in self-defense to defend our territory, to defend our people. So only then it is justified. But today countries blatantly break these norms and they operate in a legal gray area. Especially US and Israel, they have developed this doctrine of preemptive self-defense. That is in anticipation of future threats based on so-called intelligence assessments. They claim to act in self-defense, which is not justified under international law. It falls into a legal gray area. So basically, they exploit the legal loopholes which are present. And when they are the aggressors, they claim that they are acting in self-defense based on an anticipated threat in the future. For example, look at how Israel has been saying Iran's nuclear weapons program is an existential threat. They are saying this from 30 years. Even 30 years ago, Israel used to say Iran is on the verge of building a nuclear weapon. That in another few weeks, in another few months, Iran will have a nuclear bomb and they'll drop it on us. And even today, 30 years later, they're still saying the same. So you can't use the excuse of imminent threat and future threats which are anticipated and use that to exercise force against the country. That is not self-defense. So they call it preemptive self-defense, and that falls into this legal loophole that exists with the UN system itself. Now let's move on and talk about the Genocide Convention. But I would like to start with a practice question for all of you. Since this marathon is primarily oriented towards your prelims exam, we will use a lot of MCQs for practice. UPSC standard MCQ questions based on the topics, and then we will discuss the topic in detail. And I want this to be as interactive as possible. I want you guys to read the question carefully and please try to answer, start answering, post your answers in the comments. I'll give you a few seconds and then we will discuss the question as well and we'll discuss about the topic as well. The Genocide Convention was the first legal instrument to codify genocide as a crime. It was the first human rights treaty unanimously adopted by the UN General Assembly. It was conceived largely in response to the atrocities committed during the Korean War. Which of the or how many of the above statements is or are correct? So can someone try to answer this question? Many students are saying B, only 2. Okay, if you're saying only 2, can you tell me which statement is incorrect? Out of the 3 statements, which of the statement is incorrect? 1 or 2 or 3? Very good. Deepak, Chauhan, very good. Statement 3 is incorrect. Very good. The Genocide Convention was indeed the first legal instrument to codify genocide as a crime. I'll explain this, don't worry. We will discuss this in detail. Statement 1 is right. Statement 2 is also absolutely correct. It was the first human rights treaty unanimously adopted by the UN General Assembly. It was adopted just one day before the Universal Declaration on Human Rights was adopted. Many students get confused over here. They think UDHR was the first ever human rights treaty unanimously adopted by the UNGA. But this was on 10th December 1948. But one day before this, on 9th December, the Genocide Convention had been unanimously adopted, making it the first ever human rights treaty that was adopted by the UNGA. Clear? But statement 3 is completely wrong. It was not a result of the Korean War. The Korean War came later. This convention was primarily rooted in the atrocities of the world wars, especially Second World War. Events like the Holocaust, where millions of innocent Jews were exterminated by Nazi Germany. How entire communities and group of people were targeted on the lines of their race, their ethnicity, their religion, their nationality. Large-scale killings were carried out across Europe especially, even in Asia as well. Imperial fascist Japan committed brutal atrocities from China to Southeast Asia. Italy, under Mussolini, committed similar atrocities across Europe. Look at the Armenian genocide, which the Ottomans carried out, or look at what Nazi Germany did with the Jews. So, to deal with such targeted mass killings, to prevent such horrors from occurring again, the Genocide Convention was brought out. So, it was a response to the horrors of World War I and World War II, especially World War II. It was not a response to the Korean War. So B is indeed the correct answer. Only 2 statements are correct. Now let's talk about the Genocide Convention in slight detail. Because today, countries like Israel are accused of committing a genocide. And look at the irony behind this. This convention was codified to protect communities like the Jews, who suffered the Holocaust, where millions were killed under Nazi Germany, thrown into gas chambers. Unspeakable horrors were committed against the Jews. But today, Israel is accused of the same crime against Palestinians. Countries like South Africa, they have filed cases at International Court of Justice, accusing Israel of committing a genocide against Palestinians, especially in the Gaza Strip. At International Criminal Court, Israeli leaders, including Netanyahu, they have been declared as war criminals. An arrest warrant has been issued against them. There is a standing arrest warrant against Netanyahu. Same with Russian President Vladimir Putin. Putin stands accused of committing war crimes, and the International Criminal Court has issued an arrest warrant against him. So as a result, these topics are extremely important for our exams. The term genocide was coined for the first time by a Polish Jewish lawyer, Raphael Lemkin. In 1944, this Jewish lawyer from Poland, He saw the atrocities against his community, as to how people were being targeted because of their ethnicity, their race, their nationality, their religion and faith. And he labeled such mass killings sponsored by a state as an act of genocide. It was a legal term that was newly introduced. And very quickly, it started gaining international traction. So, post Second World War, the term genocide started entering legal discussions and law books. And it paved the way for an international convention to be brought out through the UN framework. So, the UN General Assembly unanimously adopted this convention against genocide, prohibiting genocide, declaring it as a punishable crime on the 9th of December 1948. And it came into force from 1951 onwards. So, under the Genocide Convention, any act of mass killing sponsored by a state where a group of people are being targeted for who they are, for their identity, such acts are labeled as act of genocide. And please note down this point, be it an act of mass killing committed during war, or be it an act of mass killing committed during peacetime, both of them get to be labeled as genocide. You can't use the excuse of war to commit mass killings on the lines of identity. You can't say that we are at war, so I'll go kill all the people of an entire nation. That is exactly what Donald Trump had threatened just a few days ago. As the deadline he had placed for Iran was expiring, I'm sure all of you must be aware of it. Donald Trump posted on social media saying that an entire civilization would die tonight. This is nothing but a genocidal threat. And this convention even covers the intent. You don't have to commit the act. Even just showing the intent to do that act is enough for the individual to be prosecuted. So leaders like Trump, Netanyahu, Putin can be prosecuted under international law as they have displayed such an intent to wipe out an entire group of people. Russia's Putin has shown the same intent and acted as well in the Ukraine war to wipe out Ukrainians. So if you're committing such mass killings to wipe out an entire generation of people because of their nationality, race, religion, ethnicity, such a criminal act is known as an act of genocide. Under Article 2 of Genocide Convention, this definition has been clearly provided. So the convention defines what is a genocide and what acts qualify to be labeled as an act of genocide. So whether it was committed during wartime or peacetime doesn't matter. Be it during war or during peace, any mass killing of a group of people will be labeled as an act of genocide, which is punishable under international law. So killing of the members of a group in large numbers, like what Pakistan did in East Pakistan against Bengalis, a classic case of genocide. What Myanmar's army, the Tatmadaw, did against Rohingya Muslims in collusion with radical Buddhist monks. All these are acts of genocide where people were targeted in large numbers for their religion, for their race, for their ethnicity, for their nationality, causing serious bodily or even mental harm to the members of a particular group, deliberately inflicting harsh conditions on a group to bring about their physical destruction, like cutting off basic supplies, like how Israel has cut off Gaza from rest of the world, turning it into an open prison. And if you remember, during the peak of the Gaza war in the last 3-4 years, Israel tried cutting off electricity, water, cut off access to medical support. So such acts which are deliberately done to cause the physical destruction of a group also gets to be labeled as an act of genocide. Any attempt to inflict deliberate harm on the conditions of life. For sustenance, what do you need? You need food, you need water, you need basic healthcare if you're injured. If a state tries to disrupt this, prevent this deliberately during war or peacetime, in order to cripple that population and try to wipe them out, that is an intent of genocide. Even issuing threats to wipe out a group of people is an act of genocide. Imposing measures to prevent births within a group or transferring the children forcibly to another group in order to prevent the next generation from being born in order to prevent that group from continuing and perpetuating. Any such attempt aimed at targeting children of a particular group in order to wipe out the group itself in that generation also accounts as an act of genocide. So, this is punishable under International Court of Justice and as well as through the International Criminal Court. Clear? The ICJ and ICC, they have the jurisdiction, they have the mandate to take up these cases. So please note down the specific acts listed under Article 3 of this convention. An act of genocide, those who commit this, it could be the leaders of a country, it could be the officials involved, even if they are following the orders. That is not an excuse. Just because the leaders had ordered the mass killings, military officials, intelligence officials, bureaucrats, if they perpetuate an act of genocide, even they are equally accountable. When the Nuremberg trials took place to hold the Nazi officers accountable, many of them gave this lame excuse that I was blindly following the orders. And they tried to escape from the penal provisions. But the Nuremberg trials clearly established the guilt of even the officials who were involved in this conspiracy. Any direct or public incitement to commit genocide is also punishable. Even the masses, the civilians, the public, if they stand with such genocidal leaders and regimes and support the mass killing of another group of people, even those civilians can be punished. As it happened in Germany, right? The German masses were backing Adolf Hitler, right? They were backing the fascist atrocities that were being carried out. So even the public, which is inciting this, playing any direct, indirect role to cause an act of genocide, all those who are responsible for that can be punished. So any attempt or even complicity in the act of genocide gets covered under this convention. But however, we don't see the strict enforcement. That again highlights the weakness of the UN system and the limited enforcement power of the International Criminal Court and as well as the International Court of Justice. Big powers like US, Russia, Israel, they often get away with these acts. Now let's talk about the next important legal document, the UDHR, that was adopted by UN General Assembly in 1948. The Universal Declaration of Human Rights. Given the number of conflicts that are going on in the world in the past 4 years, I think the topic of human rights can also be very important. And this document is a sacred document in international law. The UDHR was adopted by the UNGA to recognize equal rights for all human beings without any distinction. In fact, this principle would go on to inspire the constitutions and national laws of many, many countries that were born post 1948. When you look at the Indian Constitution, right to equality under Article 14, and the right against any sort of discrimination on the lines of religion, race, place of birth, sex, etc. It draws inspiration from the UN framework, the Universal Declaration of Human Rights. So the UN committee under Eleanor Roosevelt, the spouse of FD Roosevelt, this committee drafted this legal document recognizing equal rights for all human beings. A set of basic rights were recognized. And this was adopted through UNGA resolution number 217. So please make a note of this. UNGA resolution 217 dealt with basic rights of all human beings without any distinction or discrimination. So this codified around 30 articles which provides for various set of basic rights for human beings. So we need to take a look at the document as well. What are those rights that are accorded? How it has inspired constitutions and laws across the world. So this is considered by legal experts, by scholars, even by diplomats, as a foundational document in the history of human and civil rights. as far as the modern world is concerned, modern geopolitics is concerned. It is this document which is seen as a foundation for recognizing basic human rights. Under these 30 articles, these rights are universally recognized. There is no distinction on the lines of religion, nationality, caste, or creed, or sex, or place of birth. In fact, the document does not mention any of those divisions that exist in our society. It doesn't even refer to religion or caste or race or ethnicity. It says that all humans on the planet, they have basic rights and equal rights. And these 30 rights are codified in these articles. So it upholds the dignity of human beings by recognizing that all humans are born free and they are born equal. You could be an American citizen, you could be a Christian, you could be a Muslim, you could be a Hindu, you could be an Indian or a Pakistani. Every human being gets these basic set of rights. So that is what sets apart the UDHR. It grants universal rights without any distinction and discrimination and applies for all human beings. This went on to inspire the International Bill of Human Rights that was later brought out in 1966, which took effect from 1976 onwards. So let's see as to what kind of rights have been provided. But first, please note down that the declaration itself is not legally binding. The UDHR in itself is not legally binding, though it is seen as part of customary international law by some countries, by some Supreme Courts. Technically speaking, it's not legally binding and it's not actually part of customary international law. It's just a declaration based on which new conventions and treaties were brought out, constitutions were drafted, new national legislations were drafted. So in that regard, based on interpretation of different judiciaries across the world, they do treat this as part of customary international law, though legally it is not, because it's not legally binding. It's a non-binding declaration, but many courts across the world, they interpret these rights as customary international law, meaning you have to follow it. Whether you have signed it or ratified it or not, doesn't matter. This is something that every government is expected to follow and uphold. Though it's not legally binding and it's not seen as customary international law, the courts have expanded the jurisdiction and interpretation. Many countries consider this to be a part of customary international law. Is that clear? Now, what are these rights? For example, basic rights such as right to life, right to health, right to education, right to asylum if you're a refugee, right to housing, which includes property rights. Such basic necessities that are required for human existence and survival, they are recognized one by one under these 30 articles which are part of UDHR. You can see the categories as well. I've added the entire set of categories over here. Right to life encompasses the right against slavery, the right against any form of torture. So this will cover bonded labor. It will cover all forms of slavery. Then if you look at Article 12 to 17, it recognizes the basic right of movement, the right to settle down in a place, the right to seek asylum, the right to exercise your property and housing rights. Then we have rights related to religion, faith, one's conscience, and freedom of thought and expression. Basic rights related to education, health, standard of living, which includes your right to employment as well. So all such rights are very explicitly defined under the UDHR, and you can see those 30 rights enlisted over here. I want you to go through this infographic later when you download the PPT. I'll share it on my Telegram channel as well, and we will upload this on our web page. You can see the link for that in the description box below. So please use the PPT and go through these 30 rights. Just be aware of it, be familiar with it. For example, Article 1 recognizes that all human beings are born free and equal. Article 2 recognizes that everybody is entitled to these basic rights without any discrimination. So like this, it goes on as we were discussing, covering right to life, right against torture, right to asylum, right to education, health, housing, right to employment, right to property. Everything gets defined under these 30 articles. Now, let's move on and discuss something related to it. Let's talk about the Geneva Conventions. Now that we have discussed the UDHR and we have discussed the Genocide Convention, let's talk about the Geneva Conventions. So please read the question. There are four lines or statements given here. You need to select the correct answer. You need to basically identify what's the purpose of the Geneva Conventions. Whom does it seek to protect? Does it protect the wounded and sick soldiers on land? Essentially, the armies which are fighting a war, if soldiers get wounded, if they get crippled, if they're no longer able to fight the war, are they covered under Geneva Conventions? Wounded, sick, and shipwrecked military personnel at sea during war. Now, this acquires a lot of importance because recently, Iranian naval warship Iris Dana was torpedoed by US Navy off the coast of Sri Lanka in India's backyard. And all the Iranian sailors, most of them lost their lives. Some of them were rescued by Sri Lanka. India, on humanitarian grounds, offered shelter to the other Iranian warship on humanitarian grounds. So, given that a similar development has occurred in our backyard in the Iran war, there can be a question related to this. Because look at the statement here. Is there any international basic protection for non-combatants or sailors who are shipwrecked, whose ship has been hit? They're no longer able to fight. Such military personnel, do they have basic human rights guaranteed? Are there any rules of engagement which prevents targeting such personnel? Right? How about POWs, prisoners of war? This again is a relevant topic. Recently, two US pilots, they ejected after their fighter jet was hit by Iranian air defense and they landed in Iran. And the US has carried out a daring rescue mission. One of the pilots was rescued within a few hours by the special op teams. But the second pilot, he was basically behind enemy lines for nearly 36 to 48 hours, surviving on his own, employing his SEER training, his survival training, and evading detection and capture by the enemy. And then US mounted a mega operation involving 150 plus aircraft. 100 plus US commandos were deployed. And in one of the most daring rescue missions ever, the pilot was safely evacuated and extracted from Iran. So this brings up the topic of POWs. How should POWs be treated? Is it covered under Geneva Conventions? Then what about civilians? Civilians are also non-combatants. They're not fighting the war. In any occupied territory or otherwise, do civilians have any basic protection during times of war? So you tell me in the comments, Geneva Conventions of 1949, does it cover just one or two or three or all the four? What's the right answer? These are the options. Let's see how many of you have answered this. Very good. At least 4 or 5 students have mentioned option D, 1, 2, 3, and 4. That is indeed the correct answer. All the 4 categories of combatants and non-combatants, they are covered under the Geneva Conventions. So what are these Geneva Conventions? Let's discuss. The Geneva Conventions refers to a set of 4 individual conventions. There are a total of 4 different conventions which collectively make up your Geneva Conventions. Following the horrors of the world wars, especially World War II, because back then there was no international law, no rules of engagement. All morals, ethics were violated. Brutal killings were carried out. Even innocent civilians were not spared. POWs would be tortured and mutilated. And soldiers who are injured, who can no longer fight, who can no longer defend themselves, even they were brutally killed. And these atrocities were committed by both the sides, not just by the Axis powers, even by the Allied powers. So to prevent such atrocities from happening again, certain rules of engagement had to be laid down for wars and conflicts. During wartime, how should enemy combatants be treated? How should civilians be treated? How should non-combatants be treated? This is defined under your Geneva Conventions. There are 4 conventions, as I told you. Convention number 1, the first Geneva Convention, provides protection for the wounded and sick soldiers on land. So let's say two countries are fighting a brutal conflict, let's say US and Iran, and a land conflict is taking place. Soldiers who are injured, soldiers who are no longer able to pick up a gun and fight, they are to be considered as non-combatants. Even when you know that the other soldier is injured, he is no longer able to fight, if you try to kill them or kill them in action, then that accounts for as a war crime, something which can be tried at the International Criminal Court, and it can be brought up at the UN, it can be brought up at International Court of Justice as well. So killing of wounded soldiers, soldiers who have become sick, who can't fight anymore on land, they are protected under first Geneva Convention. The second Geneva Convention applies the same logic for seafarers and sailors at sea. Those who are on a damaged ship, if they have suffered a shipwreck during conflict, these sailors, they are no longer capable of fighting the war. Those who are seriously injured, those who have fallen sick, these sailors and naval officers cannot be targeted, right? You have to consider them as non-combatants, and you should spare their lives on humanitarian grounds. Then, when enemy soldiers are captured, when they become prisoners of war, they are also accorded with a set of basic rights. They can't be tortured, their basic human rights can't be taken away. This reminds me of how India upheld the Third Geneva Convention during 1971 war, when India held up to 93,000 Pakistani POWs. India, being a responsible nation, it treated the POWs of Pakistan with great respect. Not one case of abuse or violation of their rights was reported. The credit goes to the then Indian leadership, the army professionalism of our armed forces. And they were taken care of, they were given medical treatment, shelter for few months as long as they remained in Indian custody. Basic food and supplies were given to them. Some of them were given basic jobs to sustain their livelihood for few months. And eventually, when India signed the Shimla Agreement and brought the war to an end, we slowly started repatriating these POWs one by one, sending them back with dignity, with complete upholding of their rights. They were sent back to Pakistan. So that is a shining example of India standing by its international commitments and humanitarian commitments. So how POWs have to be treated, right? That is defined under the Third Geneva Convention. And for civilians, including civilians in an occupied territory, that includes territories like Gaza, West Bank, which is part of Palestine, civilians at any cost cannot be targeted. Even if an active war is going on, in the name of targeting the enemy, you can't go and blatantly kill civilians in the process. Take, for example, what Israel did last week, how it bombed Beirut, targeted Lebanon, and it said it is justified because they are targeting Hezbollah, which is an extremist group. But in the name of targeting Hezbollah, Israel dropped hundreds of bombs in central Beirut, which is a densely crowded city, that too during daytime. You have hundreds and hundreds of civilians, women and children. 350 plus people were killed. And what is the justification given by Israel? That we were aiming at Hezbollah's leaders, and few Hezbollah leaders were killed. While Hezbollah is a legitimate military target for Israel, you cannot kill civilians in the process. You can't justify that action on any grounds. You might be going after terrorists, you might be going after an enemy state, but any war should be limited only to combatants. Another excuse given by countries is that the enemy is using a human shield, that they are deliberately covering themselves in a civilian location so that we don't target them. Even that cannot be an excuse. If they are using civilians as a human shield, that blame lies on those elements. You can't go and bomb those areas or target civilians just because you're going after your legitimate targets. So any such killings that happen is a violation of the Fourth Geneva Convention. When you know that there are civilians located and you still take a decision to strike the target. So such acts, they are labeled as war crimes, as crimes against humanity, which can be tried at international courts. So please make a note of these conventions, very, very important. They are seen as part of customary international law and it is legally binding. Whether you have signed it or not doesn't matter. Even if there is a country which has not signed it, these basic rights will apply for everyone. Every state and even non-state actors, they have to follow this. Please note down, this is another important distinction. It applies for both state actors and even non-state actors. They have to ensure that they abide by these four Geneva Conventions. Now let's talk about the ICC, the International Criminal Court, which is also in the news again and again. The ICC is an intergovernmental organization that is set up to deal with war crimes, accusations of genocide, crimes against humanity, etc. Any major violation of Geneva Conventions and Genocide Conventions that can be tried under the ICC, which was established in the year 2002. It was established through the Treaty of Rome, also called the Rome Statute of 1998. The Rome Statute came into force in 2002, leading to the establishment of this Intergovernmental Criminal Court, the ICC, the International Criminal Court. It is headquartered at The Hague in Netherlands, which is also considered as the judicial capital of the world, because this is where the International Court of Justice is also headquartered, the primary judicial organ of the UN. And even the PCA, the Permanent Court of Arbitration, is also headquartered at The Hague in Netherlands. So these four acts are specifically covered under the Rome Statute. An act of genocide, crimes against humanity, primarily targeting civilians, crippling basic services to civilians, targeting hospitals and schools. At the start of the Iran war, I'm sure many of you must have heard, in the city of Minab, an American airstrike hit a school where close to 170 school girls were killed. Right? Any such act of aggression where schools, hospitals have been bombarded. Israel is accused of targeting aid workers as well. Israel is accused of targeting those who are providing basic aid and delivery. So any such act gets labeled as a crime against humanity. If you're deliberately causing hunger to an entire population, taking away water and power supply, preventing medical aid from reaching, all these acts are crimes against humanity. If you're destroying critical infrastructure, like how Trump has threatened that he will bomb Iran to Stone Age, destroy all power plants and energy infrastructure, that accounts for a crime against humanity because you're trying to deprive an entire population of basic services. So such acts labeled as crime of aggression, right? They will be liable for prosecution under the ICC. Under the International Criminal Court, it is individuals who can be prosecuted. Individuals who are guilty of these crimes, they can be prosecuted. Not an entire country or a government. It's not the entire state. Individual leaders who gave the orders, a president, a prime minister, an army chief, or military officers, or officials of an intelligence agency, those individuals who are responsible for these four crimes, they can be tried at the International Criminal Court. That is why the ICC has issued an arrest warrant against Putin specifically, against Netanyahu, his former defense minister, against Hamas leaders as well, who carried out the October 7th attack. So any act that falls in these four categories can be tried and arrest warrants can be issued. Please note, India is not a party. We have not signed the Rome Statute, so there's no question of ratifying it. We are not part of the ICC. Same with US and China. Such major powers are staying out of it. See, for India, since we have a number of internal conflicts from Naxalism to Northeast insurgency to Kashmir insurgency, India never wanted to take the chance because generally this gets misused. Global powers can misuse such frameworks and they can try to interfere in your internal security and internal matters. So, given the security concerns we have and the internal sensitivities of India, we have decided not to be part of the Rome Statute. Now, who can bring up these cases to the notice of ICC? Who can file the cases here? It can either be a state party which has been affected. One of the state parties, whether they are affected or not, can bring up the matter to the attention of the ICC. The ICC has a dedicated prosecutor, which acts as an independent organ, the office of the prosecutor, who will take up these cases. So a state party, a member, can refer the cases, or UN Security Council also can refer the cases. And even the office of the prosecutor can take up suo motu investigation on their own based on media reports and public statements. Even suo motu investigation can be opened. And if evidence is found that officials or leaders were involved in ordering these crimes, then they can be tried at the ICC by issuing an arrest warrant against them. But however, ICC is a toothless tiger. It's a toothless body because it has no enforcement powers of its own. It doesn't have any police force to carry out the arrest. It depends on the cooperation of the member states. So if a war criminal were to enter a country which is a member of the Rome Statute, then that member country is obligated by law to arrest that individual and hand him or her over to the ICC to face the punishment. But generally, big leaders of big global powers, they will get away with it because no member state would dare arrest someone like Putin or Netanyahu. And also, you might have seen why Putin and Netanyahu avoid traveling to some countries where they do not have good relations. Right? If that country is a member of ICC, they might arrest them. And that's the reason why they avoid certain countries. So, though it has a moral effect and a limited effect, it can't really bring about any real enforcement unless and until the member states are willing to cooperate. So, very few countries and leaders have been tried and prosecuted through ICC. A few African dictators. Recently, the former leader of Philippines, right? He was transferred to the ICC's custody. Apart from these rare cases, other big powers and big leaders never face any penalties or punishment through the International Criminal Court. That shows the limitation of the ICC. Now, moving on, let's talk about another important treaty, a treaty-based organization, the NATO, which has been hitting the global headlines in the last 4 years. UPSC has already asked questions related to NATO, but I'm pretty sure the topic might repeat as well. If you've seen PYQs, UPSC tends to repeat certain popular topics, and NATO is definitely one amongst them. So the North Atlantic Treaty Organization, what is it? We will go a little deep into this topic today. We'll not only look at the members and the purpose of this organization, we will look at the recent issues and controversies as well. We will try to further analyze certain important facts related to NATO, which could be relevant from a prelims point of view. So this organization is a treaty-based organization founded in 1949 through the North Atlantic Treaty, also known as the Washington Treaty. It was founded right after the Second World War as the Cold War rivalries were beginning between the US-led Western democracies and the Soviet-led communist Eastern Bloc. So as these ideological differences came up and the world order became divided between two superpower blocs, the Western democracies, led by US and West European democracies, they established the NATO as an intergovernmental military alliance. It's a military club. It's an exclusive military club of Western democracies. And today there are 32 member states, 29 from Europe, 2 from North America, and Turkey, which sits at the crossroads of Eurasia. Recently, 2 countries have joined from Europe. Previously, it was 27 European countries. In 2023, Finland joined the organization. Then Sweden in 2024. also joined the organization. This was a direct response to the Russian aggression against Ukraine. After the Ukraine war began and Russia became more and more aggressive, the Scandinavian countries of Finland and Sweden felt threatened as they are in the same backyard and they have joined the NATO. So today it has 32 members in total, including Turkey, and from North America it is US and Canada. So this organization is headquartered at Brussels in Belgium. So let's see what is the purpose of the organization. Since it's a military alliance, it promises collective defense. Under Article 5 of the Washington Treaty, the principle of collective defense is provided. So, according to principle of collective defense, any attack by a non-member on a member state will be treated and perceived as an attack on all the countries, all the members of the group. And they will collectively organize the defense of that member. They'll come to the support of that member which has been attacked by a non-NATO country. Let's say, for example, if US were to be attacked by a non-NATO country and US invokes Article 5 of Washington Treaty of the NATO, then all the NATO members must come to the support of US to defend US collectively, deploying troops, deploying their military assets. That is the principle of collective defense provided under Article 5. This principle, however, has been invoked only once. In the entire history of NATO, it has been used only once after the 9/11 attacks. After the 9/11 attacks carried out by Al-Qaeda, when US declared war against Al-Qaeda and planned to invade Afghanistan, which was ruled by the then Taliban regime, the NATO allies saw this as an attack on a fellow NATO member, and under the principle of collective defense, they all contributed troops to a coalition force, the International Security Assistance Force, that was approved by the UN Security Council as well. The UNSC approved the invasion of Afghanistan by this International Security Assistance Force, a coalition force led by US and other NATO military powers. Some of you might be wondering, how come NATO members are not coming to the defense of US in the ongoing Iran war? Can you think about it? Because Trump has been open in asking support. He has asked the NATO countries to come to the support of US, especially to clear the blockade at Hormuz. But be it Spain or be it Italy, be it France, UK, all of them have rejected the request of Donald Trump. On what grounds can they reject it? Can someone explain this to me? I will explain it a little while later, but can you think as to why NATO members have not come to the rescue of the United States in the Iran war? Let me see if you guys can answer this. Before that, let's discuss the membership and how the group has expanded over the years. So when NATO was established in 1949, these were the founding members, primarily made up of Western democracies. They all had a common ideology, a belief in democratic principles, a belief in a capitalist economic model. So from Belgium to Denmark to France to UK to US to Canada and Portugal, they were all part of this military alliance. Then throughout the Cold War period, from 1950s to 1990s, some of the countries in the Mediterranean belt, they started joining NATO. Spain, for example, Turkey, Greece, then of course Germany, following the reunification of Germany in 1989, as the Berlin Wall fell, marking the collapse of the ideological divisions, right? These countries went on to join the NATO. Then came the disintegration of the USSR, the end of the Cold War period, the collapse of the communist states. And we saw a rapid expansion in 1990s and early 2000s. This is what we call as the eastward expansion of NATO. Just see how quickly NATO expanded eastwards post 1991 with Poland, Czech Republic, and Hungary, previously part of the Warsaw Pact and the Soviet bloc, right? They all started joining NATO. Then in the early 2000s, even former Soviet territories like Estonia, Latvia, Lithuania, your Baltic states, which until 91 were part of the USSR, They also went on to join the NATO, and it has continued to expand with membership of Montenegro and North Macedonia from the Balkan region, from the southeastern part of Europe. So the war in Ukraine is entirely centered around NATO's membership and its eastward expansion. One of the prime reasons why Russia attacked Ukraine was because Russia feared that Ukraine might join the NATO. NATO membership was being offered along with the membership of European Union, and Ukraine was showing a lot of interest to join both NATO and EU to align with Western powers. This was seen as a threat by Russia because once you join the NATO, there are some commitments that you will take up. As a NATO member, you have to increase your defense spending. Back in 2006, the defense ministers of NATO set a spending target of minimum of 2% of their GDP on military modernization. This is a mandatory goal that NATO members have to meet. Every member will have to spend at least 2% of their GDP on defense expenditure and defense modernization so that their armed forces are prepared. They need to allow NATO troops and NATO weapons to be stationed in their country, like how American air defense systems have been deployed in Poland. American Patriot and THAAD missile systems, rocket systems have been deployed in Poland. American troops are present in Germany. So allowing NATO troops, allowing the deployment of NATO weapons and arsenal is mandatory requirement. You have to align with the military and strategic goals of the entire bloc. So these are the commitments that a member would be taking upon. Now, let's take up one more question related to NATO's membership. Since two countries have recently joined, Finland and Sweden, in 2023 and 2024 respectively, let's see how many of you know about the membership criteria and the membership process. How many of the below given statements is or are correct? NATO membership is potentially open to all of Europe's emerging democracies. New members must be invited by a consensus of current members. NATO membership is contingent on a country's military forces being under firm civilian control. Which of the statements is or are correct? Let's see how many of you can get this right. Take a few seconds. I'll explain the membership of NATO. What's the criteria that the countries look for? What's the process that is employed? See, all three are correct. Chauhan, Pallavi, Deepak, very good. All three statements are correct. All the three are right statements. So let's understand this. See, as per the Washington Treaty, this military alliance was created primarily to uphold the security of the North Atlantic states. That is, all your Western democracies that are centered around the North Atlantic. They are mainly located above the Tropic of Cancer, and they are littorals of the North Atlantic region. Could be Canada, US from North America, and primarily the European powers. So any European emerging democracy by that logic is eligible for membership, right? It mainly accepts powers from the North Atlantic region, stretching from Europe till North America, with all European emerging democracies eligible for membership. There is no explicit criteria as such. The treaty does not define a checklist or a criteria, but there are certain basic requirements to consider a membership. First and foremost, the country should be a democracy. It will not accept dictatorships, authoritarian regimes and leaders, though there are a couple of members who have shown dictatorial tendencies, but at least for the namesake, they still remain functional democracies. So being a functional democracy where constitutional principles, human rights, diversity is upheld is a mandatory requirement. Though it's not explicitly mentioned, this is one of the criteria. It has to be a democratic power. Next, it should have a free market economy, a capitalist economic model, meaning state control over the economy should be almost limited or nil. The state should only be an enabler, and it should allow for private investments, private capital, free markets to basically dominate the markets. So this again is a requirement. The military forces must be under civilian control. You can't have a military dictatorship. There should be a popular elected government, a representative government to which the armed forces are reporting. The armed forces, they have to be subordinate to the elected government which is in power, a civilian government that has been elected to power. They must commit to respect the sovereignty of the neighbors, the borders that they share. They should not use acts of aggression. I mean, by this logic, US doesn't really fit the bill as it has been known to violate sovereignty of other nations. But this is seen as one of the requirements, especially that of the neighbors. The sovereignty of the neighbors cannot be threatened and violated. And it must have compatibility with NATO armed forces in terms of technology, in terms of weapon systems, in terms of military hardware and logistics. Because without compatibility, how will different armed forces work together if they ever have to interoperate in a combined mission or a joint mission? Don't you think the soldiers should be well versed with each other's weapon systems and tactics and communication protocols? So this compatibility is a requirement. And then, as I said, spending minimum 2% of the GDP was made mandatory from 2006. Okay, let's see as to how much the countries are spending, what's the issue that Trump often raises, and today how much NATO countries are spending, what percentage of their GDP are they spending on military modernization. So the initial target laid in 2006 was 2% of their GDP, but just 8 countries out of the then 31 members were meeting the target. See, this is where Donald Trump has a legitimate criticism against NATO, that US has been sharing the bigger burden. US is the one which is doing the heavy lifting in terms of funding, in terms of troops, in terms of weapons, in terms of military technology. And because of NATO, the European powers, they largely became complicit with regard to their own security. One reason why Russia dared to attack Ukraine was because it knew that European powers, they have become outdated in military terms. From Britain to France to Germany and all the other European military powers, they have become complacent over the last 7 decades. They have not made enough investments in defense and in their own security. So here Trump definitely has a legitimate criticism. Why should US bear the burden of European security? Only 8 countries were meeting this 2% of the GDP target out of the 31 members that were there. Right? So that is the main point of concern that Trump has often highlighted. So now NATO countries have set a target of 5% of their GDP. After Russia's attack on Ukraine and the ongoing conflict in Eastern Europe, now European countries have woken up to the threat and they're all spending massively on defense expenditure. In many countries, the defense budget has doubled. We are seeing on an average 20% increase in year-on-year expenditure from European countries. For example, if you look at even Canada and the European powers, their military expenses have been jumping by 20% on a year-to-year basis. And for the first time in NATO's history, all the members, all 32 members, have met the 2% target. This had never happened before in the history of NATO. Right? Or as recently as 2016-17, just 8 to 9 countries were spending 2% of their GDP. But now every member, all the 32 members, have met the 2% GDP target, and now they're being pushed by Trump to spend more, up to even 5% of their GDP. So let's see which countries are the biggest contributors. This could be a probable prelims question, right? UPSC might ask you, which NATO member spends the highest on a per capita basis on defense expenditure? The answer to this question is not the United States. It's actually Norway. For the first time, a country other than the US has increased its per capita expenditure on defense. Norway has been spending more than $3,000 per capita on defense, followed by US at the second position. This is with regard to per capita terms. Clear? Please remember the top 2. If you take the overall funding, the overall money being put into NATO, right? The volume of money being pumped, then US is the number one contributor with $980 billion. With regard to the volume of funding, US is definitely number one with $980 billion. That's almost a trillion, right? Followed by Germany at the second position, up to $121 billion. Then UK at the third position with up to $92 billion. So European countries have significantly increased their defense budget in the last 4 years since 2022. It took the attack by Russia against Ukraine to pull out European powers from their slumber. They had become very complacent, as I told you. They were finally pushed after the war against Ukraine began, realizing the threat posed by Russia and other security challenges. And now they have started spending more on defense to look after their own security. And especially after Trump came into office, European leaders have realized they can't rely on United States, right? They can't trust a leader like Trump, or in general, US can't be trusted as a reliable partner. So finally, European powers have stepped up their defense expenditure. That's why you are seeing this big jump in defense spending. Clear? Now, let's cover another interesting fact. UPSC may ask a question on which countries are members of both European Union and NATO. The common members. Or it might give a list of countries and it might ask you to select which of them are members of EU but not NATO. Or the other way around, list of countries, which of them are NATO members but not part of European Union. So please be prepared for this question. This Venn diagram is enough. The only change, there is one correction you have to make. It's a slightly old infographic. Sweden, after joining NATO, also falls into this bracket. Sweden is both a member of EU and NATO. That's the only change correction you have to make. Austria, Cyprus, Ireland, Malta, they remain just EU members. These countries here from US to Albania that are listed here, they are just NATO members, not part of the other group. And here you have the common list of countries that are both members of EU and NATO at the same time. Belgium, Bulgaria, Italy, Germany, Greece, Hungary, now Sweden as well, Finland, Poland, Portugal, Baltic countries like Estonia, Denmark, and the others. They're part of both EU and NATO. So please remember this. Next, another important fact. A map-based question can come. Which NATO countries share a border with Russia? Right? These are favorite topics for UPSC. For example, when there was conflict in Ukraine, conflict in Afghanistan, standard border questions were asked. Which countries share borders with Ukraine or Afghanistan? Now, since NATO is repeatedly in news, Ukraine war continues to drag. Trump keeps poking the NATO members. There might be a question on which NATO countries share a direct land border with Russia. Can you answer this? There are 6 NATO members sharing a direct land border with Russia. Norway, Finland, Estonia, Latvia, Lithuania, and Poland. Please look at the map. See, this is Finland. After it joined NATO in 2023, there was a significant expansion in NATO's borders with Russia. More than 1,000-kilometer border of Finland was added. Russia also shares a small border here with Norway. Right? Then you have the Baltic states. We have Estonia, Latvia, Lithuania, the former Soviet republics, which went on to join EU and NATO, sharing a direct border with Russia. Then even Poland, you can see here. How come Poland shares a direct border? Because Russia is located far away from Poland. That's because of a Russian exclave located here facing the Baltic Sea. This is your Baltic Sea. Now, can someone name this Russian exclave in the comment section? I'll not tell you the name of this Russian exclave. It's a Russian territory bound by Poland and the Baltic states. What is this small Russian territory called? Russia has a strategic military base, a naval base, and a port located over here, giving it access to the warmer waters of the Baltic Sea. That's why Poland also becomes a NATO member sharing a border with Russia. So please find out the name of this exclave, this location, and mention that in the comment section below. Next, another related topic. UPSC may ask which NATO countries share direct border with Ukraine. Since Ukraine was seeking NATO's membership before, and that was the precursor to the war, there might be a question of a geography map-based question on these lines. Which NATO countries share a direct border with Ukraine? The answer is 4 NATO countries: Poland, Slovakia, Hungary, and Romania. Look at the map again. Poland, Slovakia, Hungary, Romania. These are the 4 countries. Belarus is not part of NATO. It's a close Russian ally. Belarus is aligned with Russia. So these 4, they share a direct border with Ukraine. So I hope you guys have written down these basic points. If not, please download the PPT later and ensure that you revise these topics at the last minute. Now let's move on to the next topic. Let's talk about the Refugee Convention. Again, because of all the wars and conflicts going on, the Refugee Convention remains in the news, and there is an Indian connection as well to this particular topic. So the topic is very, very important. The Refugee Convention of 1951. Why was this convention brought out, and what's the purpose? What kind of rights does it accord to refugees? What obligations does it place on a country which has accepted the Refugee Convention? That is something we'll discuss. And we'll also understand what is India's engagement with the Refugee Convention. Have we signed it? Have we not signed it? So we'll understand the status with regard to India. So the Refugee Convention is also referred to as the Geneva Convention of 1951. Now, please don't confuse this with Geneva Conventions. That's plural. That refers to your war-based rules of engagement conventions, the 4 conventions we discussed. This Geneva Convention is different, right? It basically gave birth to the Refugee Convention following the massive refugee crisis that Europe was dealing with post-World War II. The Second World War, which had caused enormous devastation and destruction, created millions and millions of refugees. Many of them lost their homes, their property, their homeland. They were driven out of their countries, and they had to settle down and seek asylum in order to save their lives. So to deal with the huge refugee population, to rehabilitate them, to protect them, to grant them basic rights, the United Nations brought out this multilateral treaty. The Geneva Convention of 1951, negotiated at Geneva in Switzerland, also known as the Refugee Convention. So initially, this convention applied according to a deadline and according to a certain geography that was defined under the Refugee Convention. It applied specifically for refugees created before January 1st, 1951. And it applied primarily for the European continent. So with regard to its geographical reach and the time period, it was restricted only to European refugees created by the Second World War. Initially, it did not apply to other conflicts, refugees in other parts of the world. When 1951 it was adopted, it applied specifically for refugees created before January 1st, 1951, which basically meant European refugees alone. And it did not consider refugees in other parts of the world. Later on, this convention was updated through the 1967 Additional Protocol. So Refugee Convention was amended. There was an update which was added to it, which removed this timeline and geographical limitation, making it universal in character. So now it applies for refugees anywhere in the world, a refugee created at any point in time. That specific time limit and geographical limitation has been removed through the 1967 additional protocol. So now Refugee Convention applies universally across the world. It aligns with the basic right to seek asylum, the right to seek protection from any persecution, which is defined under Universal Declaration of Human Rights. Now, let's say a war is taking place in your country, and maybe the government is targeting, the armed forces are targeting a specific set of people, people of a certain religion, people of a certain ethnicity, which means you're being persecuted, you're being targeted for your identity. So you will try to save yourself, right? You'll try to save the lives of your family, your friends, and you will run away from the country and seek protection in another country. So those who leave the country fearing for their lives, those who are being persecuted by the state itself, they fall under the definition of refugees. Initially, it applied specifically for European refugees, but now it has universal application. But still, India has chosen not to be a party to the Refugee Convention and the additional protocol. And you know why? Initially, we rejected the Refugee Convention because it was Eurocentric. It specifically applied to Europe, not covering other parts of the world. So it seemed like a Western colonial sort of imperial imposition, and we did not take up these responsibilities. Even after additional protocol was added in 1967, India did not want to take up the commitment because don't forget where India is located. We are located in one of the most volatile regions in the world, that is South Asia region. In almost every neighboring country of India, there has been some or the other crisis, from war to major disasters to even internal coups and serious political economic crisis situations. India has dealt with multiple refugee scenarios, from Tibetan refugees when China annexed Tibet in 1950 to the refugees driven during partition by Pakistan, both from West and East Pakistan, or during the 1971 conflict, especially when Pakistan targeted the Bengalis and how 10 million Bengalis sought refuge in India, or the Sri Lankan ethnic conflict, where lakhs of Tamil refugees targeted by the Sinhala Buddhists sought refuge in India. So India has been affected by multiple crisis situations, wars, and conflicts in the neighborhood, and we were mindful of this. So India didn't want to take up any binding commitments because once you sign and ratify it, you are obligated to uphold all the commitments. So does it mean we don't protect refugees at all? No. India treats or handles the refugee issues on a case to case basis, right? Depending on the circumstances, depending on where the refugees are coming from, what circumstances they are dealing with. Depending on that, India comes out with a policy, executive policy. But we don't have a law, we don't have a policy to deal with refugees. So we are not party to the 1951 Refugee Convention, nor to the 1967 Additional Protocol, and we don't even have a dedicated law or a policy for this. On a case to case basis, we have dealt with the refugee problems. And generally, India has been very welcoming towards refugees. India has displayed that a bigger heart, accommodating lakhs of refugees from Tibet, from Pakistan and East Pakistan, from Sri Lanka, from Afghanistan as well, from Myanmar, right? So, in most cases, India has been accommodative of refugees because accepting refugees is a part of your international commitment. Whether you sign the convention or not doesn't matter. If a refugee shows up at your borders begging for mercy to save their lives, their family members, because they are being targeted in another country where a crisis or a war is going on, you can't turn them away. You can't seal your border and say you go back to your country. You can't say that. It's a humanitarian obligation under customary international law to accept refugees. If you send them back to a place where they might be persecuted and targeted, then you will violate one of the core principles of the convention, that is the principle of non refoulement. Please write this down. Recently, India was accused of violating the principle of non refoulement when it decided to deport Rohingya refugees back to Myanmar. Since the Rohingya minorities continue to face heightened threat in Myanmar. They might be persecuted by the radical Buddhists or by the Myanmar army. If India decides to send them back, it's a violation of this core principle. According to principle of non-refoulement, you can't send back a refugee to a place where they might be targeted and persecuted. Which means if a refugee shows up at your doorstep asking for asylum, you need to accept them. Later on, either that government will take care of the refugee, providing them with some basic rights. The refugees also have some basic responsibilities on them. They have some obligations on them. And if a country decides not to shelter the refugees, but it has allowed them to enter on humanitarian grounds, then it can direct them towards the UN High Commissioner for Refugees, which will provide the required support for the refugee population. In Delhi, the UNHCR runs a major office where several refugees get the basic help and protection. India would allow them to enter the country, but Indian government may not be able to take care of their basic needs and necessities. So such refugees are directed towards the UN High Commissioner for Refugees. But we have accommodated several refugee groups, as I told you, from Bengali refugees to Tamil refugees to Tibetan refugees. So those countries which have signed and ratified Refugee Convention and additional protocol, they have some obligations on them. They have some duties that are expected from them. So the parties to Refugee Convention, they have to accept the refugees and provide them basic necessities. Give them shelter, give them food, give them medicine, right? You can't deny first aid. You can't deny access to healthcare. You can't deny even the basic standard of living, which means they should be allowed to take up jobs, earn for themselves. You should give them access to courts so that they can secure justice if someone violates their rights. So refugees are given these basic rights that you can see here. From right to life, to right to food and water, right to medicine and healthcare, right to education, right to employment, right to a certain standard of living, right to dignity. These basic rights have to be accorded to the refugees. Is that clear? A government should ensure that these necessities are fulfilled. And at the same time, refugees also have obligations on them. They have to abide by the laws and policies of the land. They can't break the law. They can't get involved in criminal activities or terrorist activities. They have to follow the law of the land, and if they violate the law, they can be punished as well. So these rights and duties, or rights and responsibilities of refugees and the governments, they are laid down under the Refugee Convention. But if you send back a refugee to their country where they might be targeted again, then that is a violation of principle of non-refoulement. Even if the country has not signed Refugee Convention, like India, right? India says we have not signed Refugee Convention, so we are not obligated. But according to customary international law, principle of non-refoulement is a binding commitment on every member country of the UN. Every responsible state has to abide by this. You can't forcefully send back a refugee to a place where they might be persecuted and targeted. So please make a note of the principle of non-refoulement. Now, another interesting point. What if war criminals try to seek refuge in a country? What does international law say about this? What does Refugee Convention say about war criminals seeking refuge? War criminals need not be provided refuge, because then they will turn it into a safe haven. Right? In a war or a conflict, leaders and officials will commit brutal crimes against humanity and war crimes. And then they'll try to seek refuge in a friendly country. So to prevent that, war criminals are prohibited from seeking refuge, and all countries are also prohibited from giving refuge to war criminals. Understood? So please make a note of all these key points. Now, since we are talking about refugees, another pressing issue in front of the world is the issue of migration, the movement of people, the movement of migrant workers, illegal migrants as well. So in this regard, there is a global convention. It's called the Global Compact for Safe, Orderly and Regular Migration. This has been in the news over the past few years. And since the topic of migration is a hot topic, especially because of rising anti-immigration trend in Western countries, in Europe, in Australia, in US, how under the Trump administration, US has been very hostile to migrants. The topic can become very relevant, and UPSC might pick a question on the Global Compact, which is a convention that deals with safe, orderly, and regular migration of people. Now, can you tell me this Global Compact is based on which framework or declaration or convention? Is it based on Ottawa framework, New York Declaration, New Delhi Declaration, or Chicago Convention? Can you answer this question? Let's see how many of you can get this right. Dheeraj Jadhav says option B. Dviti also says option B. Priyadarshini also says option B. Okay, very good. Option B is the correct answer. The New York Declaration laid the groundwork for the Global Compact on Migration to be adopted. It was adopted by the United Nations. See, Chicago Convention mainly deals with civil aviation. The International Civil Aviation Organization was mainly established through Chicago Convention. There are multiple New Delhi declarations from G20 to the recent AI summit, right? So that's not the right answer. New York Declaration is the correct answer. Now, what is this Global Compact? What does it deal with? What provisions does it contain? The Refugee Convention deals with one set of people who are called refugees. As I told you, refugees are the ones who are trying to save their lives. There is a threat to their lives because of war, because of conflict. Uh, the ones who are in power, the ones who are in majority, might be targeting the smaller minority groups because of their religion, ethnicity, or race. So when they try to save their lives by fleeing to another country, asking for asylum, they are called as refugees, where there is a threat to life, they're trying to save themselves. So for protecting refugees, we have these conventions and rights that we already discussed. It's obligatory on every country to give asylum and protect their basic human rights, to protect their life. But Global Compact on Migration deals with legal migrants, illegal migrants. It even applies for IDPs, internally displaced people. Within a country, people might get displaced because of a conflict. Look at how Tamil civilians were displaced in Sri Lanka because of the ethnic war. Or look at how Indians have been displaced because of, let's say, Naxalism, Northeast insurgency, or Kashmiri Pandits who were targeted by the terrorists in J&K. So they become IDPs, internally displaced people. So the Global Compact on Migration primarily lays down a framework for safe, orderly migration, covering migrants, IDPs, and illegal migrants as well. So it's an intergovernmental agreement through the UN covering all aspects of international migration. It seeks to promote legal migration. It seeks to streamline legal migration, make it safer for legal migration, those who are seeking work opportunities, educational opportunities. It seeks to curb down illegal migration. See, no country can accept illegal migrants, right? It will become a burden eventually. So there is a distinction between refugees and illegal migrants. Please understand this. No country is obligated to take in illegal migrants because they are not facing any life threat. They are entering another country illegally without a valid visa because they don't have the eligibility and they want a better standard of life. They're coming for job, for earning more money. They want a better life in another country, which is better off than their own country. So there is no obligation on any country to accept illegal migrants. Right? At the same time, you have to facilitate legal migration for legitimate purposes. So that is the focus of this Global Compact. It creates a framework for the global community. It was endorsed by the UN in 2018 through the New York Declaration, based on which multiple rounds of talks took place, and by 2021, this Global Compact was finalized. But please note, this compact is not binding. It can't be made binding. No country would accept a binding framework on migration, right? Because they will see it as a intrusion into their sovereignty. So it's a non-binding framework, but it creates a streamlined process for countries to cooperate to deal with migration related issues. It strengthens governance related to migration, documenting the migrants, making it easy for visa immigration clearance, regulating border controls, ensuring that migration is sustainable, meaning it can't facilitate any form of illegal movement of people, right? And if at all illegal migrants are entering, how should a country handle that? It has to be done in a humane manner. You can't take away the basic rights of illegal migrants, right? Every country has a right to detain and deport illegal migrants, but you can't violate their human rights. You can't mistreat them, you can't abuse them, you can't exploit them. The reason why I'm mentioning this is because last year, when the Trump administration started deporting illegal migrants in large numbers, many thousand Indians were deported as well. But what was troubling was many Indian illegal migrants, they were handcuffed, they were mistreated, they were not even given food and water, they were brought like criminals and deported to India. Now, this is not tolerable. You can't mistreat illegal migrants, you can't abuse them, humiliate them, affect their dignity. You can detain them, deport them, but you can't mistreat them, abuse them, and exploit them. So when US did this, India did not object. We didn't raise a major formal objection. So that's why I feel the topic could be relevant. The Global Compact lays down these conditions as to how illegal migrants have to be dealt with. It creates a global support framework, a cooperative framework that aligns with SDG goals of the UN, the Sustainable Development Goals of the UN, to facilitate safe and legal migration while clamping down on illegal migration. So that is the purpose of the Global Compact on Migration. Now, moving on, we are entering the 1960s. Let's talk about a very important treaty in the news, the Indus Water Treaty. The Indus Water Treaty between India and Pakistan. I'm sure most of you must have read about it. You must be aware, but there's no harm in revising it because these marathons, one-shot marathons, they're meant to help in your quick revision, last-minute revision, right before the exam. So don't get complacent thinking I know everything, right? Let's go through all the high-priority topics which have been in the limelight for the last 12 to 18 months. Let's talk about the provisions of Indus Water Treaty and some recent developments. So as you know, it's a water sharing treaty between India and Pakistan to share the waters of the Indus drainage basin. Now, the Indus drainage basin or the Indus river system is made up of 6 major rivers. And these 6 rivers are divided into the western and eastern rivers. So this treaty was mediated by the World Bank and signed in 1960 between India and Pakistan. Pakistan was extremely worried because it's the lower riparian state located in the downstream of all these rivers, whereas India has a natural geographical advantage. We have a greater ability to control the flow of these rivers and the water availability because we are an upstream country, upper riparian country. So to address the concerns of Pakistan, India showed a bigger heart in the interest of acting as a responsible state, abiding by international laws. We engaged the World Bank as a mediator and worked out the Indus Water Treaty. So this treaty divides the basin into western and eastern rivers. Look at the map here. The western rivers include the Indus, Jhelum, and Chenab. The eastern rivers include the Ravi, Beas, and Satluj. Now, if you take the overall water allocation, it's in the ratio of 20:80. Pakistan gets 80% of the allocation, India gets around 20%. But it is a relatively fair allocation because India has greater rights over the eastern rivers to take care of India's domestic requirements. But our usage rights is limited over western rivers. we have limited usage rights over Indus, Jhelum, and Chenab. So India can use only a part of the water of Indus, Jhelum, and Chenab. We can only build run-of-the-river projects, such as a hydroelectric dam. We can use some amount of water for agriculture, for navigation, for fisheries, etc. But rest of the water, we should allow it to flow into Pakistan, almost 80% of it. So India's rights over Western River is largely restricted and limited. We can take up some projects to take care of local needs in J&K, Himachal Pradesh region, but it's only for run-of-the-river projects where we don't divert the river. We can't stop the flow of the water into Pakistan. We can't divert the flow of the water. We can't create a disadvantage for Pakistan. But India can utilize its limited share which has been allocated. So non-consumptive uses are allowed for navigation, for basic application in the region. Non-consumptive usage is allowed, limited rights are given, and India has taken up many projects on the Jhelum and Chenab. But when it comes to eastern rivers, India has a higher degree of control. India has complete rights to develop any water project, any dam and hydropower project, divert the water as well to some extent for irrigation and agriculture and drinking purposes. And only a small portion of the waters of eastern rivers should be allowed to flow into Pakistan, mainly to maintain the natural ecological flow and to serve the needs of Pakistan in the downstream areas. So this treaty clearly favors Pakistan more than India, but India agreed to it, not because it was a compromise, but it was the right thing to do. You never should weaponize water. You shouldn't play geopolitics with water. That was the understanding of that era. It was a different era, different period altogether. But given that Pakistan has become hostile increasingly, sponsoring terrorism against India, going to wars against India repeatedly, destabilizing Kashmir, backing multiple terror groups, trying to break and split India, it has become unsustainable for India to live up to the commitments under Indus Water Treaty. Especially after the Uri attacks of 2016, there has been a heightened debate within the Indian government and within our strategic circles that should we weaponize the Indus Water Treaty. But subsequent governments from many decades have decided against it. Because weaponizing water would go against basic human rights. You will end up punishing innocent Pakistani civilians. Our problem is with Pakistani state, mainly the deep state, the army and the ISI and the terror groups, not with the innocent civilians of Pakistan. And also it could backfire. It could be counterproductive. If Pakistan's agriculture is affected, if Pakistan's water availability is affected, Pakistani civilians might start resenting India, which could serve the interests of the Pakistani deep state and the terrorist groups. It could help in their radicalization and recruitment against India. So, given these ground realities, until last year, we had decided never to weaponize Indus Water Treaty. Even after Pulwama attacks, India did not weaponize Indus Water Treaty. But last year was the last nail in the coffin. The Pahalgam attack led India to suspend its commitments. We have now kept this treaty in abeyance. See, many media outlets, they misreported this. They said India is withdrawing from the treaty, suspending the treaty. Please understand it can't be done. You can't withdraw or suspend. There is no such provision. If you look at the terms of the treaty, there is no exit clause. There is no specific provision which you can invoke to exit, withdraw, or suspend. So India has innovated. It has used very smart diplomatic and legal language, saying that we will keep the treaty commitments in abeyance, meaning we will not follow the commitments unless and until Pakistan stops sponsoring terrorism, right? India can't allow blood and water to flow together. This has been our standard position for many decades. So now we are seeing the enforcement of this with India keeping the treaty and its commitments in abeyance. For example, under the treaty, we have the Indus water commissioners, essentially the water secretaries of both countries. They were meeting periodically every year at the start of the year, usually on the 1st of Jan. They meet and they exchange hydrological data. There is constant exchange of hydrological data to manage the water flow during summer months and the monsoon season, mainly to manage droughts and floods, to prevent disasters from occurring. And also, we exchange information on any existing projects, upcoming projects, any upgradation that is planned. Pakistan was even allowed to send officials to visit the projects on the Indian side or the proposed projects and raise objections if it felt a concern that India was violating the terms. In the past, Pakistan has often misused this and it has filed cases against India at Permanent Court of Arbitration and also at the International Court of Justice. With regard to Kishan Ganga project, Baglihar project, it had dragged India to the PCA. But all the rulings went in favor of India, as India was largely committed to the terms of the treaty. So now, when India says we are keeping this in abeyance, it means we will no longer hold the meeting of the Indus water commissioners. It means we will no longer share hydrological data, which will leave Pakistan in the dark about droughts and floods. And we will go beyond the treaty to fully utilize the potential that exists by upgrading the projects, by planning new projects, maybe. For example, India was restricted from desilting operations. You can't increase the storage by removing and clearing the silt on the western rivers because that will affect water flow into Pakistan. So after the Pahalgam attack, after we kept the treaty in abeyance, India has carried out slushing, where you remove the slush, the sediments are taken out to increase the storage capacity. And in the long term, we are planning new projects to ensure that we fully utilize these waters, which could become a new diplomatic tool, a coercive tool to punish Pakistan. So, in this context, you should also be aware of some key projects which are coming up on the Indus rivers and the ones which are already existing. For example, on the Chenab, India has major hydroelectric projects including Pakaldul, Kiru, Kwar, and Ratle. Ratle is a major upcoming hydroelectric project on the Chenab. So please make a note. Then we have carried out the slushing activity or reservoir flushing to remove the sediments in the Salal and Baglihar projects, which are also built on the Chenab. Then coming to the Tulbul navigation project, also known as the Vular barrage. It's built on one of the tributaries of the Jhelum. It's part of the Jhelum river stream that facilitates local navigation and feeds the famous Vular Lake in Kashmir. Then we also have the Kishan Ganga Dam and Hydro Project, which Pakistan has often objected to. It's built on the Kishan Ganga, which is a tributary of the Jhelum. It goes on to join the Jhelum. So please remember the project names and on which river has it been built. Because these projects have been in the headlines over the past year and there can be questions related to Indus Water Treaty. Now moving on to the next topic. We are in 1960s right now. So there are other important treaties, conventions which will come into picture, starting with the Antarctic Treaty System. The Antarctic Treaty System has its origin in the 1950s-60 period. So this creates a governance framework for the Antarctic region, the region around the South Pole. So when you look at the Antarctic region, after the Second World War ended, many countries were raising territorial claims over the South Pole and some territories and the water bodies in the Antarctic Circle. We had Argentina, we had South Africa, Australia, some European powers as well. Even US and Soviet Union were very keen to exert their influence because Cold War rivalries had started. So with regard to territorial claims in the Antarctic, the counter claims of each other, it was building up tensions. It was becoming the next flashpoint where a potential conflict could have broken out. So to prevent this from happening, a new treaty system was created, the Antarctic Treaty, which led to the establishment of the Antarctic Treaty System. So today, this treaty system, the ATS, it's a collection of multiple treaties. It provides for the governance framework of the Antarctic region. So it acts as a arms control treaty. It also declares the region as part of global commons, meaning this region belongs to the whole of humanity. No country can claim sovereignty over here. No country can exercise sovereign rights. No country can say this region belongs to us. So the concept of sovereignty was erased below 60 degrees south latitude. So it's not just Antarctica, but the sea around it, the land and sea present below 60 degrees south, gets covered under the treaty system. And the concept of sovereignty doesn't exist over here. It sets out the Antarctic region purely for scientific research, exploration, and expeditions to better understand the Earth and the universe and life. So only scientific research is allowed. Large scale mining, mineral projects are not allowed. Militarization is not allowed. Testing of nuclear weapons is not allowed. Even setting up military bases, deploying naval assets, carrying out military exercises is prohibited under the Antarctic Treaty System. So, this is one of the global commons. Is that clear? The treaty system sets out Antarctica and the region around it as part of the global commons with no scope for any country to exercise sovereignty claims. So, this system is administered by a secretariat, the Antarctic Treaty Secretariat, headquartered in Buenos Aires, Argentina. Now, let's quickly look at its history and India's participation in this treaty system. So, by 1950s, I told you that conflicting claims were coming up from multiple countries. So, by 1959, the United Nations was trying to diffuse this crisis. It had declared the year as International Geophysical Year to focus on the geophysical heritage of planet Earth. So this region was identified as a critical region from a scientific perspective, from an environmental perspective. Finally, countries which were raising counterclaims against each other, 12 of them, they worked under the framework of the International Geophysical Year to negotiate this treaty called the Antarctic Treaty that came into force from 1961. They worked out the treaty in 1959. After further negotiations and changes, it was signed and brought into effect by 1961. Today, the Antarctic Treaty and the entire system it has created consists of 56 parties. 56 countries are part of it, with 29 of them having consultative party status. And India is also one of them. India entered the treaty system much later in 1983 under Prime Minister Indira Gandhi, when India started prioritizing polar research and expedition, understanding the scientific significance and the strategic significance of these projects. India joined Antarctic Treaty System, and today we are also one of the consultative parties. This enables India's scientific expeditions and exploration activity in the South Pole. So as you know, India has gone on to establish multiple research stations over here, starting with Dakshin Gangotri, which has now become defunct. Then we had set up the Maitri and the Bharati research stations. Now Bharati is almost becoming outdated. It will be decommissioned very soon. It will be replaced with Maitri 2. India is setting up a new research facility. So these are India's major scientific initiatives with regard to the Antarctic region. Now, under the Antarctic Treaty, as I told you, sovereignty claims cannot be made. Any existing disputes stand cancelled. This is declared as part of global commons belonging to the entire humanity. It is set out only for scientific research and expedition. So militarization is banned. Testing nuclear weapons is banned. Deploying military assets is also prohibited. Conducting military exercises is also prohibited. So please note down the key provisions of the Antarctic Treaty. So later on, other treaties also have been added to the system, which makes up the collective Antarctic Treaty System. So this is the mother treaty. The 1959 Antarctic Treaty is the mother treaty, under which there are three more treaties. The Convention for Conservation of Antarctic Seals, to protect the seal population, which plays a critical role in the food chain and in the marine ecosystem. This convention was adopted. Convention on Conservation of Antarctic Marine Living Resources, to protect the marine aquatic life. This is a region of immense biodiversity. and it's essential to protect the marine living resources. And a recent protocol on environmental protection, mainly to deal with pollution of the Antarctic. As human activities have gone up, expeditions have increased, scientific exploration research has gone up. It has created a threat of air and water pollution, the overall impact of global warming and climate change, ozone hole depletion, and as well as the introduction of hazardous chemicals and metals because of increased human activity. That's why the protocol on environmental protection. Countries have to abide by these environmental standards when they focus on scientific expeditions in the Antarctic. It also facilitates limited tourism. And please understand, this region is uh, it's free from any native population. It doesn't have any local native population, right? Whoever is there in the Antarctic region, they're all primarily researchers, some set of tourists who go in and come out, and it's essentially a outside population which is allowed to remain here. Now, India has increasingly aligned with the goals of the Antarctic Treaty System. We are party to all the treaties. We have set up multiple research stations. We are actively involved in expeditions in the region. Recently, Indian Parliament has enacted a law. The Indian Antarctic Bill was passed. So today, the Indian Antarctic Act helps India align with the goals and priorities of Antarctic Treaty System. So under this legislation, we have implemented the principles and some of the goals of the Antarctic Treaty System through a national legislation. It allows India to step up its involvement in the Antarctic. It basically gives effect to all the commitments India has made to protect and uphold the environment and biodiversity of the Antarctic. It also extends the jurisdiction of Indian courts to foreign citizens as well, if there are any major violations that are carried out over here. Because see, today excessive tourism is taking place. And as a result, there is a heightened risk of severe pollution and environmental degradation of Antarctica. So, along with Indian nationals who might break these treaty commitments, even foreign citizens, if they were to violate the terms, they can be tried in an Indian court under the new law. If they are responsible for any significant pollution, contamination of this virgin environment, then they can be tried under Indian law and punished under Indian law. It creates a dedicated fund to push for more expedition and research projects. And it highlights India's commitment for protecting the environment of Antarctica. We have set up a dedicated committee under the Ministry of Earth Sciences, and it prohibits any hazardous activity in Antarctica. Could be mining, dredging activity, right? Any such environmentally hazardous activity is prohibited under this law. So, through this national legislation, India has aligned with the principles of Antarctic Treaty System. Now, since we were talking about global commons, it reminds me of another part of our planet and another part of our universe, which is also seen as part of global commons. It's outer space. Outer space is also designated as part of global commons under this international treaty, the Outer Space Treaty. So let's take a quick look at the provisions of Outer Space Treaty because the topic is regularly in the news. See, Outer Space Treaty was brought out in 1967 through a resolution of UN General Assembly. Through this UNGA resolution, the Outer Space Treaty was adopted, and it essentially bans any claims of sovereignty. Just like no country can claim Antarctic region, similarly, no country can claim outer space or any celestial bodies, be it the moon, be it any asteroid or comet or other planets, the resources found on them, or all the orbits around the Earth, from low Earth orbit to geostationary orbits. None of these space-based celestial bodies and assets cannot be claimed as sovereign resource or sovereign territory by any government. This is prohibited under the Outer Space Treaty. It also places a cap and restriction on militarization. For example, it bans the deployment of nuclear weapons and weapons of mass destruction. So please make a note. Under Outer Space Treaty, there is a dedicated article prohibiting the stationing of nuclear weapons and weapons of mass destruction in outer space or on any celestial object. Is that understood? But it does not prohibit the deployment of military satellites or dual use satellites, which are used for surveillance, which could be used for targeting, right? Which could be used during wartime. It doesn't prohibit ballistic missiles, which enter the exoatmosphere briefly before they re enter and strike the target. So, such form of militarization is not prohibited, but only the placement of nuclear weapons and WMDs is prohibited under the Outer Space Treaty. It sets out outer space as part of global commons, as a resource belonging to entire humanity, where every country has a right to explore and study outer space and even utilize uh, the advantages of outer space. But however, it clearly lays down the responsibility of states. Governments are primarily responsible for any space mission or project coming out of a country, even if it's from a private space company. Let's take, for example, private space companies like SpaceX or Blue Origin in the US. If these private space companies were to cause some damage, let's say one of their rocket components falls back on Earth, causing some harm, or let's say they end up creating a lot of space debris, which could threaten future space missions. In any such scenario, it's not just the private company which can be held liable, but the government of that country, which is the United States government, is responsible for all the space activities, including its private space programs. Same with India as well. We have a public space agency, ISRO, but now we have opened up the space domain for private participation. We have space startups. So, overall liability, responsibility lies with the government for any space mission coming out of the country. Any object lost in space, any object which crashes back into Earth, causing some damage on the ground, or any space debris in orbit which could threaten future space missions, eventual obligation is with that respective government of the country, even if it is a private space project. This is a key part of international law recognized under the Outer Space Treaty. I'm mentioning this because recently rocket components of ISRO's missions, they were found in Australia, found in Sri Lanka as well, and ISRO had to send a team to recover the objects. If at all some damage had been caused, we would be liable to pay compensation as well. And of late, as space launches are going up, more and more space debris is getting created, especially with entry of private companies like SpaceX, which are deploying thousands and thousands of satellites as part of the controversial Starlink project. It raises serious concerns about space traffic and debris management. So, because of all these reasons, Outer Space Treaty is very, very important. Clear? And also because of the Artemis 2 mission that was recently launched, the astronauts who safely came back and splashed down. Because of that development as well, the topic becomes very important. Now, let's look at all the space related treaties that exist. They are related to one another. So, let me take you through the space related legal provisions in international law. In 1959, the COPUS was created, the Committee on the Peaceful Uses of Outer Space, because by 1950s, a space race had begun between US and the Soviet Union. Just like they entered into an arms race and a nuclear race, they entered into a space race as well, especially after the Soviets placed the Sputnik into orbit, and it triggered a race to the moon as to who will land astronauts for the first time on lunar surface. So this was turning into a geopolitical rivalry. It was no longer just a scientific competition. It turned into a geopolitical rivalry with possible military consequences, especially with development of ballistic missiles and the common links between ballistic missiles and rockets. So the Committee on Peaceful Uses of Outer Space was set up, which led to the Outer Space Treaty of 1967, prohibiting the deployment of nuclear weapons and WMDs. But as I said, it doesn't prohibit deployment of military satellites and dual-use satellites. Then came the rescue agreement. As manned missions were being pursued by these two global powers, there was a concern as to what would happen if astronauts get lost in outer space. So, in such a scenario, every spacefaring country will have to assist the other country, share technology and resources in order to retrieve the astronaut safely, if possible. Let's say American astronauts get lost in space because of an accident and they're not able to come back. Then Soviet Union was obligated to assist the US by sharing its resources and technology and efforts. So this makes any rescue of astronauts a global effort, right? If the country alone is not able to deal with the crisis, and if astronauts' lives are at risk, every spacefaring nation will have to step up and assist the other country. There is a Space Liability Convention that clearly places the responsibility for any accidents, any damage caused by space objects. As I told you, the concerned states will be responsible even for a private launch. So there is a dedicated convention for this that codifies this provision of the Outer Space Treaty. The liability, the compensation would be borne by the respective state. Next, every launch will have to be registered. There's a registry maintained through the UN. The UN Secretary General, that is the UN Secretariat, has to be informed about any launch and any placement of objects in space. And orbit allocation is also streamlined. It is a centralized system through the International Telecommunication Union, which is part of the UN. It assigns the orbits. You can't place a satellite wherever you want. To avoid any accidents, right? Orbits are approved, licensed by the ITU, and appropriate approvals, permissions will have to be obtained through the UN Secretariat. So this maintains a level of global coordination as well. Then there is a Moon Agreement that forbids the establishment of military bases and weapon systems on the lunar surface. Setting up any military installation, fortification on the moon is prohibited under this agreement. Now, India is a party to Outer Space Treaty, the Rescue Agreement, Liability Convention, and Registration Convention. However, we have not ratified the Moon Treaty. Since China and other major powers, including US, have not ratified it, India also has not ratified the Moon Treaty, meaning countries are keeping the right to possibly militarize the moon if required. So today you are seeing a new competition, a new space race between US and China. If back then the competition and the race was between US and USSR, today a similar competition has broken out, primarily over moon landings, deployment of astronauts on the moon, with even potential habitable human bases in the coming decades. Both China and US have this ambition to set up human colonies on the moon in the coming years, triggering a new space race amongst them. So that's why the Moon Treaty is very, very significant, and India has not ratified it. Now, let's talk about the Artemis mission and the Artemis Accords, which is also a part of the global treaty framework. This is a US led initiative mainly to go back to the moon. The US lunar missions, they ended back in 1980s after Apollo 17, as they were very expensive, risky, and because of the technological complexity and the very little return on investment, NASA shut down its moon program, the Artemis program. Now, after nearly 53 years after the last major launch, NASA has gone back to the moon just a few days ago. So Artemis Accords, it's a set of agreements that US government has been signing with other interested partners. The US is reviving the lunar mission, the objective to place humans back on the moon as it enters into this new race with China. And It's participating in a collaborative initiative with multiple countries, and that includes India as well. So, just a few days ago, a couple of weeks ago, NASA launched the Artemis 2 mission, where for the first time, a woman astronaut, a person of color, a foreign national, okay, astronaut from Canada, they were basically sent on this flyby mission. It was not a landing mission. They did not make a moon landing, right? It was a flyby mission where they orbited just once around the moon and returned back to Earth with a successful and safe splashdown. Today, 61 countries have joined the Artemis Accords of the US. You can see the entire list over here, and India is also one of the key participants. So, under the Artemis Accords, the main focus is to revive lunar exploration and focus on joint missions, including missions to the International Space Station. See, that's why recently India managed to send an astronaut to the International Space Station, which was a part of a collaborative effort. It was a SpaceX launch, but it was a result of the collaboration with the US. India is also preparing for its first manned space flight under Gaganyaan mission, which is coming up. Hopefully, if everything goes well, by 2027, India plans to launch Gaganyaan. And the first set of Indian astronauts have been trained. And one of the Indian astronaut already has flown to the ISS on an American mission. So Artemis Accords facilitates such collaboration. US is helping India in the Gaganyaan mission to train the astronauts. And the recent mission to the moon, Artemis 2, is a historic milestone. You can see the set of 4 astronauts. This is the first ever moon mission, a manned mission after 53 years after the Apollo program was shut down. So this has big global implications because eventually NASA plans to land the astronauts and possibly set up human habitations and bases. And that is precisely what China also wants to do. So this aligns with our Chandrayaan mission, right? India also has ambitious missions slated under Chandrayaan program. After landing a rover at the south pole of the moon, India is making another ambitious attempt to collect samples and return the samples back to Earth. And we are collaborating with Japan. And Japan is also a participant in the Artemis Accords. So that is why this topic is very, very important. Now let's move on and talk about a very important convention, which is again in the news, the UNCLOS, the UN Convention on the Law of the Sea. So this is a different format of the question. It's a match the following type. You have maritime limits defined under UN clause and the extent described over here. You need to see whether they are correctly matched or not. Territorial waters measured up to 24 nautical miles from baseline. Contiguous zone measured up to 12 nautical miles beyond exclusive economic zone. Exclusive economic zone or EEZ up to 200 nautical miles from baseline. Which of the above pairs is or are correct? So this is your question. Now, let's take a short break. Now that we have discussed for almost 2.5 hours, I'm sure you need some break to refresh yourselves. Let's take a 20 minutes break. We'll come back at 8:45. By then, I want you guys to answer this question in the comments. Is that clear? Let me know what's the correct answer in the comments and we'll take a 20 minutes break. I'll come back at 8:45 sharp and we will resume the discussion. We are already halfway through this marathon. Just few more topics left. Hopefully another 1.5 to 2 hours, we should be able to wrap up the session. The whole idea is to make this a useful, productive session so that 30 plus treaties, conventions get covered. And even if 2, 3 questions come out of it, it's totally worth your time and effort. So I hope you guys are liking the session and understanding all the topics. So if you do, please like this video, press the like button, share it with other aspirants so they can also benefit. And don't forget to drop in your comments. So 20 minutes break. Let's come back at 8:45 sharp. Hello everyone, welcome back to the marathon session. So please let me know if the audio video is fine, if I'm clearly audible and visible so that we can resume the session. So before the break, we have covered a number of treaties and conventions. Now we were about to talk about the UNCLOS. So we were starting with this practice question. Yes, audio video is fine. Great. So many of you have already answered this question correctly in the comment section. The right answer is option C, 3 only. 1 and 2 are incorrectly paired. Territorial waters does not extend up to 24 nautical miles from the baseline. Contiguous zone is also wrongly defined over here. So don't worry, I'll explain what do you mean by territorial waters in contiguous zone. The third one is correct. EEZ extends ideally up to 200 nautical miles from the baseline. So 3 is the only correct answer. Now, what is UNCLOS, the UN Convention on Law of the Sea? This topic has been regularly in the news, either because of the South China Sea dispute, where China is unilaterally claiming the maritime territory of other countries in Southeast and East Asia, or also in the context of the Iran war and the blockade of Hormuz Strait. You might have heard India demanding that Iran should respect freedom of navigation, which is a basic international right guaranteed under the UN Convention on the Law of the Sea. So in this context, it becomes important to understand what is UNCLOS. This convention was signed in 1982 and it came into effect in 1994. So this convention basically defines maritime jurisdiction. It defines the territorial boundaries and the jurisdiction that a coastal state enjoys in the marine domain. So any coastal state will, of course, exercise a certain amount of territorial sovereign rights. There are a lot of resources that are found in our seas and oceans where economic rights will have to be extended. But where exactly these rights will end? What kind of jurisdiction should be provided in different maritime jurisdictions? And what happens in international waters? What law, what jurisdiction will apply in international waters? So to define this, the UNCLOS was brought out. Today you have 172 parties to it. There are 171 countries that have signed and adopted the UNCLOS along with the European Union. Even non-state territories, including Palestine, Cook Islands, Niue, even they have adopted the UNCLOS. Recently, countries like Austria, Dominican Republic, Panama, they have also ratified the UNCLOS. So this brings the topic into limelight. So under the UN Convention on Law of the Sea, the maritime boundaries and the jurisdiction is clearly drawn and defined. This will help regulate the seas and the oceans and the rights that a coastal state can enjoy. It will also help address any disputes that might come up with regard to sharing of the jurisdiction and the resources. Or let's say if a crime were to occur in international waters or territorial waters, it depends on where exactly the crime has taken place in order to apply the corresponding jurisdiction. Whether it applies under Indian law, can we try those cases in Indian courts, or will international law apply? To decide this, these boundaries are very, very useful. So this is seen as an extension of a country's boundaries and sovereign rights. So under the UNCLOS, the deep sea which exists, the deep sea bed, and the high seas that are present beyond any national jurisdiction, they are set aside as part of global commons. Just like the Antarctic region and outer space, they have been declared as global commons belonging to all of humanity. Similarly, the region known as the high seas, it is located in international waters and it lies beyond national jurisdiction, beyond your exclusive economic zone. These high seas are governed under the international framework. No country can claim jurisdiction in the high seas. Same goes for the deep sea bed. Beyond a certain depth on the ocean floor, the subsoil, and the seabed, whatever minerals, resources can be found here, they are governed under the international framework and countries cannot claim exclusive rights. So there is a set of our seas and oceans where countries can exercise these rights. There is a part of it where it is declared as part of global commons. So to understand this distinction and the categorization, we need to use the help of these images and break down each and every jurisdiction separately. So let us start with the first distinction, which is identified by the UNCLOS. Now assume that this land that you're seeing here is part of a coastal state. It's a littoral of a sea or an ocean. So whatever water bodies are present behind this imaginary baseline, this dotted line that you can see here, which is roughly hugging the coastline of the country, this imaginary line called the baseline serves as a reference from where the jurisdictions are identified. So any water body present behind the baseline, it could be internal waters, it could be archipelagic waters, they all become part of a country's sovereignty. A country will enjoy full sovereign rights over its internal waters and archipelagic waters. For example, you take a coastal lagoon, backwaters, estuaries, delta. So all these internal water bodies present along the coastline, these wetland ecosystems present in the ecotone, where the terrestrial ecosystem meets the marine ecosystem. All these inland water bodies that are present behind the baseline, they are called internal waters. For a country such as Maldives, which is made up of archipelago of islands, so the baseline is on the outer circle of the islands that are located, and the waters located within becomes the archipelagic waters. So even that would be a part of a country's sovereign right, where it exercises full rights and full jurisdiction. Whatever rights a country exercises on land, the same rights and jurisdiction applies in internal waters and as well as in archipelagic waters. This is as good as the country's territory. Now, from the baseline towards the seas and the oceans, these different boundaries are drawn, starting with territorial waters. Territorial waters, they extend up to 12 nautical miles from the baseline. From this imaginary reference line, 12 nautical miles distance is measured, and that marks the territorial waters of that particular country. Now, in territorial waters, a country will exercise full rights and jurisdiction. As the name itself tells you, it's as good as your own territory again. Just like internal waters, archipelagic waters belong to that country, it can completely control movement of vessels as well. Let's say a foreign ship were to enter your internal waters or your territorial waters, you can deny access to them. If you believe a ship is posing a security threat, it could be a commercial vessel or a foreign military vessel, you can deny entry into these waters, which means freedom of navigation does not exist in territorial waters and as well as in internal waters and archipelagic waters. I'll repeat my point, please pay attention. In territorial waters, there is no freedom of navigation which is guaranteed in territorial waters, internal waters, and archipelagic waters. Because this is where a coastal state gets to exercise full sovereignty and full rights and full jurisdiction. It can even prevent the entry of foreign vessels, both commercial and military vessels. But however, if a foreign vessel establishes innocent passage, it can exercise the right to pass through even territorial waters. meaning a foreign vessel could be a commercial vessel or a military vessel. Maybe it has to pass through territorial waters for practical reasons. In order to navigate and reach the open waters, it has to, let's say, go through territorial waters of a particular country. That vessel can seek the permission of the coastal state. And if it establishes that it is just an innocent passage, it doesn't pose a threat to the country's national security or to its environment, then the country can decide to grant permission or deny permission. So, right to innocent passage is available in territorial waters. Let's say a Chinese ship, maybe a warship, but for some reason they have to pass through Indian territorial waters. So Chinese vessel can ask India for permission, and if India feels that this is an innocent passage, that they're not spying on India or not posing a security threat for us or not posing a hazard for our environment, if this is established, then India may decide to grant innocent passage. It is up to the coastal state. Even here, the coastal state can decide whether to allow the vessel or not. But right to innocent passage exists in territorial waters. The moment you leave territorial waters, you're entering international waters. This is where the complete jurisdiction of a coastal state ends. The moment you cross the 12 nautical mile, you are essentially in international waters, where a country has only partial rights and jurisdiction up to a certain extent, and beyond that, the high seas will begin, where international law alone will apply. Now, in these international waters, there are a couple of different zones, such as the contiguous zone that you can see here. After territorial waters, you have contiguous zone, which is part of international waters. It extends for another 12 nautical miles. From the edge of territorial sea, if you measure another 12 nautical miles, this band of water in international waters becomes the contiguous zone where a country will have limited rights and limited jurisdiction. For example, to protect the coastal marine environment, to deal with oil spills, to deal with pollution, or to impose taxes and duties, or to deal with organized crime like drug smuggling, arms smuggling, terrorism, piracy. For these specific subjects, the coastal state can exercise limited rights and jurisdiction in the contiguous zone. But please note that once you're in international waters, freedom of navigation is a guaranteed international right, a fundamental right accorded by the UNCLOS. Unless and until the vessel is not really posing a major security threat or environmental threat, no country can stop or prevent the movement of vessels in international waters. This applies even for contiguous zone. In contiguous zone, since it's part of international waters, freedom of navigation applies over here. Without a valid reason, a country cannot stop or inhibit the movement of vessels. The same applies for the airspace above it. Till the point where territorial sea extends, the airspace above it is national airspace, where a country can even restrict the entry of aircraft, completely control the airspace above it. But the moment you cross this, you are entering international airspace. So freedom of overflight is guaranteed in international airspace. Just like freedom of navigation is guaranteed in international waters, similarly, the airspace above it, which is international airspace, their freedom of overflight will apply. So you can't prevent the movement of aircraft, intercept them, threaten them. This is not allowed under the UNCLOS. So contiguous zone allows a coastal state to exercise some limited rights in the field of taxation, tackling crimes, security, and environmental control. Apart from that, the state will have no other rights. Let's say if a crime or a murder takes place in contiguous zone, even at a distance of 13 nautical miles, let's say for example, then this country's laws will not apply. The criminal laws will not apply. If the same crime took place in territorial waters, then the state and its authorities and courts will have full jurisdiction. Let's say a murder has been committed here in territorial waters of India. Indian police, Indian law enforcement, Indian courts can exercise jurisdiction. They can detain the vessel, they can arrest the accused, investigate the case and try the case as per Indian law under Indian criminal justice system. But if the same murder happened in 13 nautical mile distance in contiguous zone, we will not have those rights. Then international law as per UNCLOS will have to be followed. Understood? Now, we have another important jurisdiction known as EEZ, Exclusive Economic Zone. This extends up to 200 nautical miles measured from the baseline. So it covers territorial waters and contiguous zone, and then it could extend up to 200 nautical miles in general. This is a general thumb rule. But it can be much lower than 200 nautical miles as well. It can even extend beyond 200 nautical miles as well. It depends on certain conditions. Now, let's say there are multiple countries packed in a small coastal body, like let's say Mediterranean Sea, Bay of Bengal, or any small gulf where 4 or 5 countries are present. You take Persian Gulf, for example, a classic example. When multiple countries are closely located, you can't alter the ground reality, the geography can't be changed. So it's almost impossible to grant 200 nautical mile of EEZ for every country. So in such scenarios, custom-based solutions, customized solutions are worked out through bilateral negotiations as per UNCLOS provisions. So in such scenarios, the EEZ might be much lesser than 200 nautical miles. And if a country's continental shelf extends beyond its EEZ, if it's going beyond 200 nautical miles, if it can establish this with geological evidence, then EEZ can be extended even up to 350 nautical miles and beyond. Countries often seek the extension of their EEZ beyond 200 nautical miles if their continental shelf is extending. But for that, you have to prove it. You have to prove with proof and evidence, geological evidence, to show that the continental shelf is extending, and you can apply for an extension of your EEZ. So it can be extended even up to 350 nautical miles, and in some rare cases, it can go beyond that as well. But once the EEZ ends, the high seas begin. So this is where national jurisdiction will end. In EEZ, a country will only have exclusive economic rights. That is, all the resources present within the EEZ belongs to that coastal state exclusively. The fisheries, the hydrocarbon resources, that is oil and gas, any precious minerals found on the seabed, in the subsoil, on the ocean floor, all those economic resources exclusively belong to that coastal state. Foreign vessels cannot come to your EEZ and poach your resources. It is not allowed. For example, a Sri Lankan fishing boat can't come to India's EEZ and try to poach our fish. A foreign vessel can't enter our EEZ to extract oil and gas or extract the minerals that are found on the seabed. The resources found in a country's EEZ exclusively belongs to that coastal state. But once EEZ ends, that is the end of national jurisdiction. So the high seas are called beyond national jurisdiction, because this is part of global commons. No country has any jurisdiction in the high seas. Is that clear? In territorial waters, a country has full rights. In contiguous zones, some limited rights are given. In EEZ, only economic rights are given. But once EEZ ends, that is the end of national jurisdiction. So pure international waters begin after EEZ, which is called as high seas. And much of the earth is covered with high seas. So only international governance applies over here. No country can claim jurisdiction or extract the resources present here or claim sovereignty in the high seas. It is set aside by the UNCLOS as part of global humanity. It belongs to the entire humanity, just like Antarctic or just like outer space. So this is how boundaries are drawn up. Jurisdiction is divided in the maritime domain. And that is why UN clause is absolutely critical. Now, what if disputes come up? Since the drawing of these boundaries and jurisdiction is quite complicated, what if two countries get into a dispute? How can the disputes be resolved under UN clause? See, as per the UN clause, there are different mechanisms to resolve the disputes. First and foremost, UN clause mandates all countries to settle any dispute through peaceful bilateral negotiations. They need not approach any judicial body or adjudication body. They need not approach UN or any international body for help. If they can work out a solution peacefully on their own, without fighting about it, without getting into a war or a conflict, without escalating tensions, without getting aggressive, if they can sit across the table in a friendly manner, talk it out and decide the maritime boundaries, then this is the most encouraged step under UN clause. Like how India, Sri Lanka, India, Maldives, India, Bangladesh resolved their maritime boundaries. Even after that, if issues persist, there are few platforms available for dispute resolution. For example, the UN clause has established a tribunal, the International Tribunal on the Law of the Sea. So this is a adjudicating body, like a judicial body of sorts, acting as a expert tribunal on these matters. Countries can approach the International Tribunal on Law of the Sea. If they don't want a hostile adjudication process, they can opt for arbitration so that a compromise can be reached. They can take the case to PCA, Permanent Court of Arbitration at The Hague in Netherlands, and whatever award is given by the PCA, they will have to follow it. They'll have to abide by the award given by the PCA. So like this, there are different mechanisms for dispute resolution. They can even take the case to ICJ if required. Since ICJ can handle interstate disputes, it's primarily set up for handling interstate disputes under the UN framework. Countries can even approach International Court of Justice if necessary. So these methods are provided so that conflict and wars can be prevented. First option is to resolve bilaterally through peaceful talks, or else there are bodies such as ITLOS, the Permanent Court of Arbitration, and the International Court of Justice. Now, the UN clause has established a new authority called the International Seabed Authority, the ISA. In order to govern the seabed, the resources found in the seabed and in the subsoil, which is in the high seas especially, the International Seabed Authority governs this entire framework. It's a intergovernmental body headquartered in Jamaica, in Kingston, in the Caribbean. And it basically implements and enforces the UN clause provisions for mineral related operations in the deep sea. Today, many countries are rushing for deep sea mining. US, China, Japan, India as well. India is planning deep sea exploration through the Samudrayan mission. And eventually, India would like to take up deep sea exploration beyond our national jurisdiction, even beyond our EEZ, in high seas, in international waters, to scout for precious minerals that can be found on the seabed. For example, polymetallic nodules. And you also find few critical strategic minerals, including rare earths, on the seabed and on the ocean floors. So you need to get a permission from International Seabed Authority. You need to get a license to explore these high seas for deep sea exploration and deep sea mining. So India has procured a few licenses from International Seabed Authority to carry out deep sea exploration in the Indian Ocean region. Now, can you find out the names of these locations? And please answer that in the comments below. This is a small homework for you. India has secured a few licenses from International Seabed Authority in the Indian Ocean region to the south of Sri Lanka and Maldives. There are a couple of specific regions where we have obtained the license for deep sea exploration and mining. Can you find out the names of these locations and mention that in the comment section? So deep sea mining is also governed by UNCLOS, by this authority established by the UN Convention on Law of the Sea. Then ITLOS, the Dispute Resolution Framework. It is headquartered in Hamburg in Germany. So there is one historic case involving India and Bangladesh. It goes back to 2014. India-Bangladesh had entered into a dispute over their EEZ, especially because of the New Moor Island, which had emerged in 1970s after the deadly Bola cyclone. Until then, it was a submerged island, a submerged landform. So the emergence of New Moor Island had created new claims from both sides, but we never fought about it. Especially post 2009, we had a friendly Bangladesh because of Prime Minister Sheikh Hasina and her government, Awami League government, which was in power. And we had fantastic relations with the government of Bangladesh. So instead of turning this into a dispute and a conflict, we both approached the Permanent Court of Arbitration, and the PCA ruled in favor of Bangladesh. Though India got to keep the New Moor Island, India had to part its EEZ with Bangladesh. We had to share a part of the EEZ and transfer it to Bangladesh. India gracefully accepted the award. Since we respect international law, we uphold international rules, and we delivered on the commitment. India never opposed the ruling. We accepted the award and transferred a part of our EEZ in Bay of Bengal to Bangladesh and settled the dispute in a peaceful manner. Now, this incident was used as an example by the PCA a couple of years later in 2016 over the Scarborough Shoal dispute in South China Sea between China and Philippines. Philippines had filed a case against China with regard to the dispute over Scarborough Shoal at the Spratly group of islands. China was clearly violating the UNCLOS provisions by claiming Scarborough Shoal and other small islands and islets to itself, though it actually belongs to Philippines. So Philippines approached the PCA, and in this ruling, the PCA went against China. It found that China was violating UNCLOS provisions and awarded the Scarborough Shoal to Philippines. So during this award, PCA cited India as a role model to be followed by China. It referred to the India-Bangladesh dispute of 2014. It asked China to learn a lesson from India, to see how India, a major power, had willingly handed over its EEZ after the PCA's ruling. And it asked China to behave in a similar manner. But as always, China rejected the award. It refused to follow the award of the PCA. And since then, the dispute between China and Philippines has escalated. So it's in this context that UNCLOS becomes very, very important. Now let's continue talking about the high seas. Let's talk about the area beyond national jurisdiction. It's a very interesting topic. What happens when national jurisdiction completely ends? National jurisdiction ends at the edge of your EEZ. Beyond a country's EEZ, right? Nobody will have a claim. This is part of high seas, part of global commons. How is this area governed, especially if environmental issues come up? Who will protect the marine species? Who will protect the marine ecosystem in the high seas? Because coastal states, they will take up responsibility if there is an environmental threat in their territorial waters or in their EEZ. Beyond that, no country would care about it. So that was a legal loophole which has recently been plugged by a new treaty which has been brought out called the High Seas Treaty. So take up this question and then we'll discuss about this. The high seas are areas beyond the EEZ of any country. I think it's an obvious statement. We've already discussed and understood what is the definition of high seas. In 2023, the Treaty of High Seas was adopted. Is it correct? This treaty focuses on protection of biodiversity beyond national jurisdictions. I think it's a fairly simple question, so let me give you the answer. All the three statements are correct. All three given statements here are correct. So option D is the right answer. As we understood with the help of the image, the map, the high seas begin beyond the EEZ of any country. Where no country's EEZ is present, that part of international waters becomes high seas. Yes, in 2023, through the United Nations, the High Seas Treaty, the Treaty of High Seas, also known as the BBNJ, was adopted. It stands for Biodiversity Beyond National Jurisdiction. It's meant to protect biodiversity beyond national jurisdiction. So it's also called BBNJ Treaty or High Seas Treaty. So when you look at the provisions, it identifies this as an international responsibility. It's a global responsibility to protect the biodiversity beyond national jurisdiction, to protect the marine species and the ecosystem in the high seas. All countries will have to act together. If you don't promote sustainable usage, sustainable exploitation and conservation, then we will see the destruction of the high seas, which makes up a large part of our planet. So that is why this treaty was adopted, and it has few focus areas that you should be aware of. Focus number one, it provides for establishment of marine protected areas that are governed under BBNJ provisions. Because see, UNCLOS applies only till the edge of EEZ. Beyond any country's EEZ, UNCLOS will not apply. So now this new treaty plugs that gap. The BBNJ or High Seas Treaty provides for establishment of marine protected areas, and it brings together the stakeholders for conservation efforts in these marine protected areas. It will involve the UN Environment Program, the concerned countries of that particular region. They would be asked to contribute. So with a combination of national efforts and international efforts, these marine protected areas will be conserved and protected. So if an oil spill occurs over here, or pollution takes place, or global warming is having a significant impact on the corals, then all the stakeholders will act collectively as per the High Seas Treaty to conserve and protect the marine ecosystems over here. It promotes sustainable use of marine genetic resources. As I told you, International Seabed Authority regulates the exploration and exploitation of resources over here. It could be hydrocarbons, minerals, even fishing can be allowed if the right permissions are taken. So it promotes sustainable usage, but it mandates that the benefits must be equitably shared. It must be shared with developing, underdeveloped countries. The benefits arising out of the exploitation should also benefit the small island states in the region. Small island states like Maldives, Seychelles. It should also benefit the coastal communities, especially the fishing communities, which are dependent on the sea for their livelihood. Because global warming, climate change poses a significant threat to small island states, developing underdeveloped coastal states and coastal fishing communities. As the sea level rises, they will face the risk of submergence, and you might see the drop in the fishing catch, which will affect livelihoods. So channeling the benefits towards these countries and communities is one of the key objectives of the BBNJ. It also establishes environmental impact assessment. It makes EIA mandatory for any such commercial activity in the high seas. Since International Seabed Authority will give licenses for mining and exploration, the concerned countries should carry out a EIA estimating the environmental damage that will occur, and they will have to invest in environmental biodiversity conservation and protection measures. Plus, developed countries, rich countries, have to provide for capacity building and technology transfer to the smaller countries, especially the small island countries and underdeveloped coastal countries. These are the four pillars of the High Seas Treaty. So I hope this topic is clear. It's very, very important because High Seas Treaty has entered into force from 2026 onwards. From this year, the BBNJ has taken effect, and that is why the topic can become very, very important. Now let's move towards weapons of mass destruction and arms control treaties. If you have noticed, today's discussion has been categorized into different segments. First, we spoke about international rules-based systems since the World War era. We spoke about human rights related treaties and conventions and those dealing with wars and conflicts. Then we specifically focused on refugee migration related issues. Then we moved towards maritime disputes and spoke about UNCLOS and BBNJ. So now we are moving to the next segment of this marathon where we will talk about arms control, arms reduction treaties and weapons of mass destruction. There are number of treaties and conventions related to this, and this again is a very, very important topic because of all the conflicts that are taking place. Plus, we also have a very dangerous situation where countries are exiting arms reduction treaties and control treaties, especially US and Russia. They are talking about resumption of nuclear testing. And there has been talk of deploying nuclear weapons in the ongoing conflicts. Very irresponsible statements have been made from Putin to Trump to even Netanyahu. And this raises a serious concern with regard to nuclear non-proliferation and nuclear disarmament. That is why all these treaties related to WMDs and arms control, arms reduction treaties are very, very critical. So let's start with the NPT, the Non-Proliferation Treaty. Which country first proposed the idea of a ban on the distribution of nuclear technology, which eventually led to the NPT? Can you guys answer this question? Which was the first country to propose a treaty for nuclear non-proliferation? It was this recommendation that eventually led towards the NPT being drafted in 1967. So was it Japan, which faced the horrors of a nuclear bombing when Hiroshima and Nagasaki were bombed during Second World War? Was it United States or Ireland or Soviet Union? Some are saying A. Some are saying Japan. But few are saying Ireland as well. See, obviously you can rule out US and Soviet Union, right? They would never ever propose such a non-proliferation treaty. Why? Because their entire dominance is based on their nuclear arsenal. Believe it or not, at one point during the Cold War, US and USSR combined together, they had 70 to 80,000 nuclear warheads with them. US had around 30 to 35,000 warheads. Soviet Union had somewhere in the range of 40 to 50,000 warheads. Just imagine that, right? The whole planet could have been destroyed, and they had far beyond what was required to even destroy the planet. At one point, during the peak of the tensions and rivalry, they had around 70 to 80,000 nuclear warheads. So definitely it's not US and USSR. You will think Japan. I saw many of you saying Japan because of its history with nuclear weapons, because of the Hiroshima Nagasaki bombing. Yes, Japan has a strong commitment for nuclear non-proliferation. It has voluntarily given up development of nuclear weapons, right? It promotes nuclear disarmament. But however, the idea was not first proposed by Japan. The answer is Ireland. It was Ireland which floated the idea, and eventually the US, which was seeking to control the spread of nuclear technology, particularly to countries like India. Because by mid-1960s, India had started out a nuclear weapons program. And the US was desperately trying to derail and intercept and destabilize our nuclear and space program. So NPT was one of the arrangements created by the Western countries, by the US especially, and the P5 countries to limit the further spread and proliferation of nuclear weapons technology. The main target was India. There were others as well, but India was the one which had started out a very ambitious program by then, by 1965-66. So every attempt was made by these powers to cripple India's nuclear weapons program. And that is the birth of NPT. So what does the NPT say? The NPT recognizes only the P5 countries as official nuclear weapon states. It basically sets a cutoff date. So whoever possessed nuclear weapons before 1967, those countries will be recognized as official nuclear weapon states, meaning they can retain their nuclear arsenal, they can advance the program, upgrade their nuclear weapons, test them as well if required, but no other country would be allowed to pursue the development of nuclear weapons. This is the provision of the treaty. It is entirely based on this principle that only those countries, it does not explicitly say P5, they smartly have put a cutoff date that whichever country had nuclear weapons before 67, they can retain their arsenal, they can develop it, modernize it, continue testing as well, but no other country would be allowed to continue a nuclear weapons program. Now, before 1967, only 5 countries possessed nuclear weapons. And which were those 5 countries? The P5, the 5 permanent members of UN Security Council, US and Soviet Union, China, UK and France. Only these 5 countries are recognized as official nuclear weapon states. Every other country was mandated to sign the treaty. All the UN member states were to sign the treaty, and if you sign it, it basically means that you will never pursue nuclear weapons. You basically have to give a commitment, an international binding commitment, that you will never seek the pursuit of nuclear weapons. If you already had a program, a nuclear research program going on, you will have to shut it down. And countries in return will get support from P5 countries for civilian nuclear technology. P5 countries will share nuclear technology and materials for civilian program. Basically, it's a way to make money, to sell nuclear fuel, nuclear reactors and make money out of it, and other countries can depend on them. This was the whole model that was proposed under NPT. As you can see, this is clearly discriminatory in nature. I mean, there's no reason why only these 5 countries should possess nuclear weapons. See, India has always been a proponent of a nuclear-free world. We would like to see nuclear disarmament. We would like to see a world which is rid of nuclear weapons. But however, strategic reality doesn't allow us to do that. Since China tested its weapons in 1960s and became a nuclear power, it became a necessity for India. It became an existential necessity for us to pursue a program to create a deterrence. To build nuclear deterrence against China, it was absolutely essential for India to retain the sovereign right to develop nuclear weapons. So at this point, Prime Minister Indira Gandhi put her foot down. India put its foot down. And India said, we will not sign this. India rejected the NPT and retained its sovereign right to develop nuclear weapons. So basically, we went against the entire world. So India's nuclear program, in a way, was an illegal program, a rogue program. So as India rejected the NPT, Pakistan obviously followed. If India would try to build nuclear weapons, Pakistan also would do it. That's how the nuclear reaction works, right? Because hostile powers will seek deterrence against their enemies. So as a result, India, Pakistan, both of them stayed out of it. And there are few others which have never signed NPT. But today, it almost has universal acceptance. Except for 4 countries. Except for 4 countries, every other country in the world had signed NPT at one point. Understood? India rejected the treaty because it was unfair, it was discriminatory. It would curb our right to create deterrence against China, which had become a nuclear weapon state by then. So, though the treaty came into force by 1970, India rejected the NPT. We boldly went ahead on our own and carried out the first nuclear weapon test in 1970s under Operation Smiling Buddha. That is when India faced more international scrutiny, sanctions, especially US would actively target our nuclear and space program, right? And India had a very difficult, long journey to finally build a mature nuclear weapons program. In 1998, under Prime Minister Vajpayee, India tested the weapons and became a nuclear weapon state. But however, we are not recognized under NPT. That's why our program was seen as an illegal rogue program. So even in 98, after the Pokhran tests, India was hit with economic and technological sanctions. So which are the countries that have never signed NPT? Please write this down. There are 4 countries that have never signed NPT: India, Pakistan, Israel, and South Sudan. These 4 countries have never signed it. India, Pakistan, Israel, they have not signed it by choice. Just like India, Pakistan retained the right to develop nuclear weapons, Israel also has done the same. And it is widely believed that Israel possesses a secret nuclear arsenal. It's like an open secret. South Sudan is a different case. South Sudan has no nuclear ambitions. It's a new country formed in 2011 after splitting from Sudan. And since then, it's going through a civil war and lot of instability. So, because of that reason, it has never signed NPT. What about Iran, which is at the center of today's nuclear weapons controversy? The entire war of US-Israel is based on this. They are primarily targeting Iran's nuclear ambition. So what is the status of Iran with regard to NPT? That's why the topic is important. Iran has signed NPT and it remains a signatory to NPT. It was not signed by the radical Shia regime. It was signed before 1979 when Iran was ruled by Mohammad Shah Reza Pahlavi, a puppet of the US. But after the Iranian Revolution, the Shia theocracy which took over, they have never exited NPT. In order to avoid greater international pressure and sanctions and scrutiny, Iran remains a signatory to NPT, but it is believed that it has pursued an illegal weapons program. That is the primary reason why US and Israel target Iran. That's why US has imposed sanctions on Iran and they continue to target the Iranian regime. There is another curious case, which is of North Korea. North Korea had signed and acceded to NPT. But later on, as differences rose between North Korea and US, North Korea and South Korea, North Korea and Japan, North Korea withdrew from NPT in 2003. It's the only country which has ever exited NPT. And since then, it has carried out multiple nuclear tests. North Korea has aggressively pursued a weapons program. It has even carried out multiple tests. So it withdrew from NPT in 2003. Before that, it had signed and acceded to Non-Proliferation Treaty. So NPT was supposed to expire in the 1990s, but it was extended indefinitely in 1995. Initially, it had a timeline. It was supposed to be implemented for 25 years. And in 95, it was extended indefinitely so that no other countries can pursue nuclear weapons. See, eventually, India's nuclear program got recognition, especially from 2004, 2005 onwards, because of the improvement in India-US relations. As we became strategic partners and signed the India-US nuclear deal, the US recognized our clean track record. India was never responsible for any nuclear accidents or leakage or proliferation, unlike Pakistan. In Pakistan, you had state elements leaking nuclear secrets to Iran, Libya, and North Korea, running a nuclear black market. So Pakistan's program never had that credibility. But India had a very clean track record that was recognized by US and later by almost every other country. Eventually, the economic and technological sanctions on India were lifted. And now countries are willing to engage with India even in nuclear commerce. In the last marathon, we spoke about nuclear suppliers group. If you go back and watch the session, you'll understand how India is making efforts to join the NSG in order to engage in global nuclear commerce. Now, coming back to NPT. The NPT is primarily enforced through the nuclear suppliers group, which is an export control regime. It basically regulates the export of nuclear fuel and nuclear material and nuclear components. And the International Atomic Energy Agency acts as a regulator, working closely with UN Security Council and UN General Assembly, and enforces the provisions of NPT. It promotes the safe and secure development of nuclear technology. It shares civilian technology with other countries. It also has the power to conduct inspections. IAEA can inspect nuclear facilities, right? So after we signed the nuclear deal with the US, India has agreed to abide by IAEA regulations. We have adopted the IAEA additional protocol. We have separated our military and civilian nuclear reactors and facilities. And IAEA inspections are allowed at our civilian facilities. But the military program remains closed, remains off limits for international inspections. Now, coming to the next treaty, the CTBT, Comprehensive Test Ban Treaty. It was designed to ban the testing of nuclear weapons, to prevent the nuclear arms race. As more and more countries were getting into weapons testing, it became essential to curb the testing of nuclear weapons because, see, by then, especially US and Soviet Union, they had conducted hundreds of nuclear tests across the world. Imagine the kind of nuclear fallout, the radiation that they have left behind from the Pacific to their own territory. They have carried out multiple bombings. But finally, in 1990s, through the efforts of the Conference on Disarmament, a nuclear test ban treaty was proposed in all the mediums and environments. See, nuclear weapons can be tested underground or on land or in the atmosphere or even underwater. US and Soviet Union have conducted all such tests, whereas India's testing has only been underground. Same with Pakistan as well. But countries like US and Soviet Union have conducted testing everywhere, in every medium you can imagine, from atmosphere to underwater to underground, even on land. So this treaty proposes a ban on any nuclear test in any environment, in any medium. It was adopted by the UNGA in 1996, but however, it has never entered into force. Why? This is the most important point. If there is a prelims question related to this, it will be based on this. See, recently, Trump has ordered US military and nuclear establishment to resume nuclear testing. Please don't neglect the topic. That's why it's very important. Recently, US has issued an official order from the president to resume nuclear testing. US and other major countries had placed a moratorium. It was a self-imposed moratorium to not carry out nuclear tests, except for North Korea, right? After 1998, no other country has carried out a nuclear test. Before that, it was India and Pakistan in 1998. And after that, it's only North Korea in the last, I would say, 26 years. No other country has carried out a nuclear test. So if US is now reordering the testing of nuclear weapons, it will trigger a chain reaction, a vicious cycle. If US were to test weapons, then Russia would follow, China would follow. If China does it, India and Pakistan will also do it. And it will push Israel and UK and France to do it. So this will trigger a much larger nuclear arms race, heightening tensions. That is why the topic is so important. So you need to understand why CTBT has not entered into force. See, 187 countries have signed it. 178 of them have ratified it. It means it almost has universal acceptance, but still it is not coming into force. Why? We'll understand that. Now, can you answer this question based on what I explained? How many countries have tested nuclear weapons since CTBT opened for signature? I'll give a hint. CTBT opened for signature in 1996. So after 96, how many countries have carried out nuclear weapon testing? What's the answer? 1, 2, 3, 4. I just mentioned it, so I hope you have caught that particular statement. You can easily answer how many countries have tested weapons post CTBT. Some are saying A, but Pawan says C. Very good. The answer is C. It is three countries: India and Pakistan in 1998, North Korea multiple times post 2003. From 2003 to 2017, North Korea has conducted multiple tests. So in the last 9 years, nobody has tested a nuclear weapon. The last was North Korea, before that India, Pakistan. Clear? Now, let's understand why CTBT has not come into force. See, according to Comprehensive Nuclear Test Ban Treaty, there are 44 countries which have nuclear capabilities, which have some form of nuclear program, even a civilian program which can be reverse engineered to turn into a weapons program. They are placed under Annex 2 of the treaty. So there is a list, there's an annexure under the CTBT, and Annex 2 contains the list of 44 countries which have nuclear capabilities. Right now, we have 5 official nuclear weapon states, that's your P5 countries, which are officially allowed to have nuclear weapons. Then we have the unofficial nuclear weapon states: India, Pakistan, Israel, North Korea. In total, 9 countries have nuclear weapons. But there are others who have capabilities, meaning if they decide, they can develop weapons if they want. Japan, for example, Germany, for example. They have the resources, they have the technology, they have the capabilities, but they have decided never to develop it. If they want to, they can do it. So there are many such countries which have the capabilities. So all these capable countries, 44 of them, that includes the 9 nuclear weapon states, they are placed under Annex 2. And there is a mandatory requirement that all the Annex 2 countries have to participate. They have to sign and ratify for CTBT to take effect, or else it will not come into force. Even if every other country in the world signs and ratifies it, if these 44 states don't do it, then CTBT will never come into force. So right now, which are the countries which have not signed it or which have not ratified it? We have China, Egypt, Iran, Israel, US. They have signed CTBT but not ratified it, meaning they want to retain the option to test. Then India, North Korea, Pakistan, which have completely rejected CTBT, meaning we want to keep the right to test nuclear weapons, because China is keeping that right, US is keeping that right, Israel is keeping that right. Clear? Then Russia had signed and ratified it, but after the Ukraine war began and US targeted Russia with sanctions, increased the threat for Russia, it has brought a new law to withdraw from CTBT. In 2023, Russia has withdrawn from its ratification. So Russia is also added to the list right now. Previously, it had signed and ratified CTBT, but now it's out of it. So without these countries implementing the ratification, it will never come into force. Now, please understand, the CTBT has established an organization known as CTBTO, Comprehensive Nuclear Test Ban Treaty Organization. It has the powers to carry out global verification to see if someone is conducting a nuclear test secretly, like how India did in 1998. The whole world was deceived by India, right? Same with North Korea as well. Its initial tests were not known unless and until the explosion happened. So to detect a possible nuclear test and levy a sanction on such countries, under CTBT, there is a global verification regime established through this organization called CTBTO. It maintains a global network of monitoring stations, the International Monitoring System, and the International Data Center. So across the world, under IMS, different types of sensors have been deployed to detect and pick up a possible nuclear test. From advanced seismic sensors to hydroacoustics for underwater tests, infrared based detection of the unique sound waves that are emitted, or the radionuclide monitoring mainly through satellites. a variety of technologies, geophysical, space technologies have been deployed. From seismic sensors to detect the unique earthquakes that are triggered by a underground nuclear test, or the mini tsunami which gets generated if there is an underwater test in a sea or an ocean, to pick up the radioactive nuclides which gets released into the atmosphere in case of a atmospheric or on land testing. There are dedicated satellites which have the capability to pick it up. So around the world, such sensors have been deployed by international monitoring system which comes under CTBTO. So it's near impossible today to conduct a secret nuclear test. The world will get to know. Recently, there have been reports. Trump has claimed that Pakistan, China have been conducting low yield nuclear tests. During Operation Sindoor, there were some reports as well, right? Though it can't be verified. Um, any test today can be picked up and detected because such technologies and sensors are deployed mainly by the CTBTO. So please be aware of this international verification regime. Next, talking about arms reduction, nuclear arms reduction. The New START treaty has just expired. Another big development. You can definitely expect a question on this. In fact, UPSC had already asked one question on New START few years ago. If you've gone through PYQs, you would know that. But there is a possibility of the topic being repeated. UPSC is known to repeat many topics. And since the New START has expired, right now there is no arms reduction treaty between US and Russia. So this can set off a dangerous chain reaction that we were talking about. So what is the New START? Strategic Arms Reduction Treaty. It was signed in 2010 and came into force in 2011. So until 2026 February, this was the only and the last remaining nuclear arms reduction treaty between these two superpowers. I told you, right? US and Soviet Union at one point during the peak of Cold War, they had at least 70,000 nuclear warheads with them. Because of these arms control and reduction treaties, they had brought it down. And today, they roughly have 1,500 odd warheads with each. And the credit goes to these treaties, starting with the SALT 1 of 1972, Strategic Arms Limitation Talks. It placed a cap on the number of nuclear arms that US and Soviet Union could possess. Then came the START 1 in 1991 that brought out a massive reduction in the nuclear arsenal of US and Russia after the collapse of the Soviet Union. It was only in 1990s we saw a significant reduction in the nuclear arsenal. In 2002, the SORT, Strategic Offensive Arms Reduction Treaty, also called the Moscow Treaty, it not only placed specific limits on the warheads and the delivery systems, it created a verification mechanism where both US and Russia could cross-verify and cross-check whether the other side was following the commitments. They even started negotiations for START 1, START 2, and START 3. But START 2 and 3 never really took off. It never really came into force. Negotiations were not even properly completed. But START 1, it remained active from 1991 to 2009 and it expired. Then the SORT or the Moscow Treaty, which had better implementation and enforcement, was all set to expire in 2012. So basically, by 2010-12 period, US and Russia would not have had any arms control reduction treaty between them if they had allowed START 1 and SORT to lapse and expire. So that's why they negotiated the New START. They signed the New START in 2010, which would replace SORT and START 1. So it came into effect in 2011 and it was supposed to expire a few years ago. But thanks to President Biden and Putin, it was extended by a few years and the new deadline was 2026. And now, given the state of relations between US and Russia, both sides have failed to extend the expiry deadline. They have allowed the treaty to lapse and expire, which means right now the world is in a very dangerous place. There's no arms control reduction treaty between them. Because of New START, the number of deployed warheads was brought down to just 1,550 for each of them. The delivery systems were also restricted. The intercontinental ballistic missiles and the other delivery platforms they were restricted to a maximum of 700. And New START was different from SORT and START 1 because it allowed on site inspections with proper data exchange and verification. Both sides could visit the facilities and inspect them to ensure that they are staying within the limits prescribed by New START. So, given the tensions between US Russia over the Ukraine war, both sides have essentially gone back and they've allowed this critical treaty to expire, which leaves the world in a dangerous place because right now they have no mechanism to exchange any information. They have no mechanism to carry out on site inspections and verification. And quite possibly, they might start expanding their nuclear arsenal as well. Donald Trump is talking about it. Trump doesn't want the treaty to be renewed or replaced because he considers China to be a threat. He believes China is accelerating its weapons program. And he believes US was at a disadvantage because of the treaties with Russia. So now, by allowing this to expire, US can now freely expand the program, even maybe carry out a test to counter China's expansion. And this creates a dangerous cycle, which might push Russia, India, Pakistan, and others to carry out expansion of their program and new testing of nuclear weapons. So that is why New START is very, very important. So since we are talking about WMDs, weapons of mass destruction, let's discuss Biological Weapons Convention and Chemical Weapons Convention. The BWC, Biological Weapons Convention, was one of the first major disarmament treaty with regard to WMDs, a multilateral framework brought out in 1975 that explicitly prohibits the development, production, usage, and storage and transferring of any bioagent which can be turned into a deadly bioweapon. See, many bioagents have been weaponized in the past, from plague to anthrax to variety of coronaviruses, and they can be easily engineered in a lab and it can be used as a deadly weapon. So, to prevent the deployment of such weapons, because such bioagents, which are enhanced with regard to the transmissibility and the mortality rates, it can very quickly and easily wipe out entire populations, possibly triggering an apocalyptic situation. Right? We have seen what the COVID-19 pandemic did. And imagine if it were to be of a lab origin, engineered to kill as many people as possible, spread as quickly as possible. Right? So, to avoid that scenario, and also given the fact that it's extremely inhuman to use bioweapons, this disarmament treaty was brought out. 189 states have become party to the treaty. It not only prohibits the development, production, usage, storage, and transferring of bioagents and bioweapons, it also mandates the destruction of all the stockpile. No country is allowed to develop and keep bioweapons with them. If they had old stockpiles, they have to destroy it. And it has to be done in a verifiable manner. So the Biological Weapons Convention has been a critical framework. And today, more or less, the world has gotten rid of biological weapons. There are rumors once in a while of some countries continuing to hold bioweapon stockpile, especially countries like Russia, China. It's alleged even US, of course, has maintained the capability, if not the stockpile. And other countries like maybe even Iran and others. In 2013, during the civil war in Syria, Bashar al-Assad's regime was accused of deploying chemical weapon agents. There have been rumors spread primarily from Russia that Ukraine was trying to develop a bioagent to be deployed in the ongoing war. But later it was proven as a conspiracy theory, as a false rumor, as part of Russian propaganda. So there have been some occurrences and instances here and there, but more or less today the world is free of bioweapons. Is that clear? And the credit goes to the Biological Weapons Convention. Similarly, we have the Chemical Weapons Convention with the same purpose and the same objective, brought out into force in 1997. It prohibits the chemical precursors which can be turned into a deadly chemical weapon. You might have heard of Agent Orange, or also called nerve agent, nerve gas, sarin gas, which is known to be a deadly chemical agent used extensively by countries like US in Vietnam War. It brings about a brutal death, causing large scale casualties. It will not discriminate between civilians and combatants. So usage of such WMDs is seen as a violation of international law, as war crimes. So Chemical Weapons Convention prohibits the production, the usage, the stockpiling, the transferring and deployment of such deadly weapons. And to enforce the destruction of the stockpile, it has created an organization known as OPCW, Organization for Prohibition of Chemical Weapons. It has set up a dedicated institution to oversee the destruction of the chemical weapon stockpile. See, even India possessed both bioweapons and chemical weapons at one point. We had both bioweapon agents and chemical agents with us. But as a responsible country, we have abided by the commitments of both the conventions, and we have destroyed all the stockpile of bioweapon agents and chemical precursors that we had. We have very strict restrictions in place to prevent any chemical precursor which could be potentially used in building a chemical bomb. So India has ensured that we remain committed to these goals. But there are few countries that have not signed or ratified the Chemical Weapons Convention. Israel, for example, please write down, Israel has not ratified it. Egypt, North Korea, South Sudan have never signed the Chemical Weapon Convention. South Sudan is an exception. You can rule it out. It has no intention to develop chemical weapons. But Egypt, North Korea remain a concern. So OPCW has the task to oversee the verification. It can conduct on-site inspections as well. And in Syria, when Assad's regime was accused of using chemical weapons in 2013 against civilian protesters, OPCW inspectors carried out field inspections. And for the role they carried out, they were awarded the Nobel Peace Prize as well. This organization has won the Nobel Peace Prize for its efforts in getting rid of chemical weapons in the world. And it's headquartered at The Hague in Netherlands. So in India, we have a dedicated authority to ensure that we abide by the commitments of Chemical Weapons Convention. It's called the National Authority Chemical Weapons Convention. It functions directly under Cabinet Secretariat so that the Prime Minister can keep a direct oversight. And by 2009, we destroyed all the chemical weapons stockpile of India. India was so committed that we enacted a law. The convention requires a national legislation. India brought out the Chemical Weapon Convention Act passed in 2000, which led to the establishment of this national authority, and with direct oversight of the Prime Minister's office through the Cabinet Secretariat, India has destroyed the entire chemical weapon stockpile. And this has been verified as well by OPCW. Now let's move on to other topics related to artificial intelligence, cyber crimes, etc. This is another set of treaties and conventions that we can talk about. Can you try to answer this question? The first ever legally binding international treaty on AI adopted recently is an initiative of which organization? Recently, a treaty with regard to AI was adopted, right? But think about it carefully. It's asking the first ever legally binding international treaty on AI. Which country or which grouping was it? Is it European Union, Council of Europe, UN, or none of the above? What's the correct answer? Last few topics. Let's quickly wrap it up. Come on. A, European Union. See, European Union has indeed brought out a law to regulate AI, but it's not the first to do it. Moreover, it's not binding on every country of the world. It applies only for EU members. UN has no such treaty. It's the Council of Europe. Council of Europe became the first grouping to bring out a legally binding arrangement to regulate AI amongst the member countries. So don't confuse Council of Europe with European Union. Both are two different bodies. It's called the Framework Convention on Artificial Intelligence, adopted by the Council of Europe in 2024. It seeks to align AI development with the goals of democracy. See, one of the main goals of Council of Europe is to protect democracies, to promote rule of law, to uphold fundamental rights and human rights and constitutional principles. So to ensure that AI is not misused, to ensure that harmful AI is not developed, which can subdue democracies, manipulate elections, this framework was created that applies for the member countries to prevent the spread of misinformation, fake news, propaganda, algorithmic bias and discrimination, and ensure that democratic institutions are protected. So this was an initiative of Council of Europe, and these member countries have signed on to this framework. From Andorra, Georgia, Iceland, Liechtenstein, Montenegro, Norway, Moldova, San Marino, to Switzerland, UK, Canada, EU, Israel, Japan, and US. So it not only includes the major European powers, it even has countries like Canada, Japan, which have signed the Framework Convention on AI. So let me give you this question on Council of Europe. Let's talk about this organization as well, because in the previous marathon, we covered European Union. Now let's talk about Council of Europe. Council of Europe was founded in 1949. Organization is one of the primary organs of European Union. The Budapest Convention on Cybercrime was brought out by the Council of Europe. Which of these statements is or are correct? See, I already gave one clue that Council of Europe is distinct from EU. It's not part of EU. Now, can you try to find out whether the other two statements are correct or wrong? Is there something called Budapest Convention on Cybercrime brought out by this organization, and was it founded in 1949? That is what you need to check. So such organizations, groupings can be very important. The treaties, conventions they have brought out can also be very relevant. Since India has hosted the AI summit, you may not get a direct question on that. Maybe UPSC will ask similar frameworks adopted by other groups, other bodies, since AI regulation is in the news. Devendra Kumar says B, only two. Very good. First and third statements are correct. So B is the right answer, but 2 is incorrect. It's not a primary organ of the EU. It's a distinct group. The Council of Europe was established in 1949 after Second World War. Its main purpose, as I told you, is to protect democracies, to protect rule of law, protect fundamental rights, constitutional principles, and human rights. It's headquartered in Strasbourg, France, and consists of 46 member countries. Most of the European countries, along with other outside powers, are part of the Council of Europe. So it's a much larger organization than European Union. It operates in parallel to EU. Is that clear? The EU is a distinct regional group. Council of Europe is a separate group altogether, mainly focused on protecting democracy and rule of law. So the Council of Europe has always been a leader when it comes to regulating new forms of technology. It was one of the first groups to bring out a convention on cybercrime, to promote global cooperation to tackle cyber crimes. It's also known as the Budapest Convention. Please write this down. Even this is related to India, because India was considering to join the Budapest Convention so that we could get support from these member countries to tackle cyber crimes which are rising. Look at the number of digital frauds and cyber scams that happen against Indians. So a few years ago in 2018, India was considering the idea of joining the Budapest Convention. The Ministry of Home Affairs, which is the nodal authority to deal with cyber crimes, was supporting this idea. But however, the Intelligence Bureau strongly opposed India joining the Budapest Convention on security grounds. Because if you join this convention, then you are mandated to link your networks, share data and information. So IB saw this as a security threat and it opposed the idea of India joining the Budapest Convention. So we haven't accepted the Budapest Convention, we haven't joined it, but it was in the news. India was considering to sign on to the Budapest Convention. So this convention was brought out in 2001 with around 68 parties, and it remains as one of the major conventions on cybercrime. See, until recently, the world did not have a global level framework for dealing with cybercrimes. Recently, UN has adopted a convention, which we will discuss next. But Council of Europe was the first body to bring out a dedicated convention to tackle cybercrimes. The countries which are part of it, they have to integrate their communication networks, share data, cooperate in investigation of cybercrimes, hand over the accused and culprits. So India saw some benefit in joining the Budapest Convention. The MHA, that's why, supported this idea. But because of objection by IB on security grounds, India has dropped the idea. Clear? Now, let's talk about UN Convention on Cybercrime. Let's start with a practice question again. Consider the following statements. UN Convention Against Cybercrime was adopted by UN General Assembly in 2024. Is this correct? It is legally binding on all UN member states once it comes into force. The UN Office on Drugs and Crime will act as the secretariat for the convention. These are your three statements. Let's see if you can answer this question. Take a few seconds and please let me know the correct answer. Pawan says 1 and 3 only. Okay. Samu and others are also saying C is the right answer. Very good. Option C is the correct answer. The UN has finally adopted a convention, a global convention on cybercrime. It was in 2024, adopted by UN General Assembly. It is administered by the UNODC, the UN Office on Drugs and Crime, that deals with organized crime, including cybercrimes. But however, it will not automatically become binding on all member states just because it comes into force. This is an extreme statement. Let's say some countries have not signed it. Let's say some countries have not ratified it, right? Even if it comes into force after achieving the minimum numbers, it can never become legally binding on all 193 UN member states, right? It doesn't work like that. So 2 is an extreme statement. So you can rule it out. So please note that this is the first such international convention at a global level through the UN to tackle cybercrimes. It was adopted by UN General Assembly in 2024 and it was adopted with consensus of all the 193 states. All the 193 UN member states have supported this, including India. It has been opened for signature and it promotes international cooperation to solve and crack cyber crimes. See, today crime syndicates are sitting in few specific countries and targeting victims across the world. You look at Southeast Asia, which has become a hub for cyber criminals. In the Golden Triangle region, in Myanmar, Cambodia, Laos, and Thailand, you have these well-oiled cyber mafias that are running these scam centers. You have large industrial scale scam facilities in the border areas of Myanmar, Cambodia, Laos, and Thailand, committing huge global level cyber scams, including digital frauds, digital arrests, etc. Even Africa, especially countries like Nigeria, Ethiopia, they have been a hub of cyber criminals and cyber fraudsters. There are Russia based and China based cyber threat actors. So, to tackle any such crimes, especially if it is organized in nature, you need global level coordination Because in the cyber domain, there is no concept of national jurisdiction, right? Your national boundaries don't apply here. The cyberspace, which is a virtual space, it creates multiple challenges with regard to law enforcement, with regard to investigation, with regard to finding out the culprits. They can even mask their identity and location and become completely anonymous. So that's why you need a global level binding treaty that promotes international cooperation. So it will be administered by the UNODC, and it mandates the countries to bring out a domestic law. Those who sign and ratify the convention, they have to bring out a national law that aligns with the UN Convention against cybercrime. They have to mandatorily cooperate with global investigations. If law enforcement agencies are seeking information and assistance or to detain the accused, the countries that have signed and ratified it, it will be binding on them to provide that international assistance. There are specific provisions to protect children, minors, from child pornography. And the biggest concern on the internet and social media is with regard to the grooming of children by pedophiles. How do you protect children from child trafficking? How do you protect them from sexual exploitation and child pornography? So this is a priority as far as the convention is concerned. There are stringent provisions in this regard. Then there are protections with regard to human rights to prevent mass surveillance, misuse of data, to promote data security, data protection. So these are the pillars of the UN Convention against cybercrime. But however, India has not ratified it. We have few concerns regarding the provisions. Though we supported the adoption initially, we have not become part of it, and India is still considering whether to ratify the convention or not. The next treaty, Open Skies Treaty, which was in the news. The Open Skies Treaty provided for some transparency with regard to missile and weapons deployment between Russia and the West. Just like a New START that allowed for mutual on-site inspections and verifications between US and Russia, so they could check how many warheads and delivery systems they had. A similar framework was created through Open Skies Treaty, where these member countries can carry out aerial surveillance. They can fly planes and or jets equipped with cameras with permission of, let's say, Russia, or Russia can do the same, to basically carry out surveillance of key military and arms deployments to prevent any miscommunication or confusion which could accidentally lead to a military escalation. So under this arrangement, both sides had agreed to keep their skies open. With the permission of the other side, they can send unarmed planes to collect aerial intelligence through aerial surveillance, so that US, Russia, and the European parties to this treaty could keep an eye on each other regarding their missile and weapon development and deployments. This would build trust. It would avoid any confusion and any miscalculation which could escalate tensions. But now, US and Russia have withdrawn from the Open Skies Treaty because of the Ukraine war and the tensions between them. So this again adds to the problems that's affecting the world. So right now, US, Russia have no way of verifying as to what is the progress they are making with regard to their arms production and arms development. There are other parties to it, primarily from Europe. But since US, Russia have withdrawn, it is a big blow to the Open Skies Treaty. And India is not a part of it, right? It has nothing to do with India. It's primarily a Cold War outcome. After the Cold War ended with the collapse of USSR, in 1992, the treaty was signed between the Western countries and Russia to allow mutual aerial surveillance missions, where unarmed planes could fly over the territory and pick up information regarding arms deployments. The next topic As I said, we are at the end of the session. Let's move quickly, very small topics left. The Ottawa Convention seen in news is related to what? Is it related to international civil aviation, marine pollution, anti-personnel mines, or UN reforms? I'll give you a few seconds. Very simple, straightforward question. Have you heard of the Ottawa Convention? It was in the news. What's the right answer? Some are saying A. Only Pawan says it is C. Okay. The correct answer is option C. It is related to anti-personnel mines. See, recently, after Russia attacked Ukraine, many European countries, especially in Eastern Europe and Central Europe, they feel threatened with Russian military aggression. They feel they could be next. So one way to prevent an invasion through your land borders is to place mines. These are pressure triggered or motion triggered explosives that are often placed underground. You might have heard that during the recent Iran war, Iran has placed mines in the Persian Gulf, in the Strait of Hormuz. Those are sea-based mines where the movement of a ship can cause a detonation of the mine. And that's one way to deny access to critical sea lanes. So just like a sea route can be mined, similarly, land routes can also be mined, where pressure and motion activated mines can be deployed underground. And if someone steps on it or someone trips the wire, the mine will explode. This is a traditional method of access denial. Laying mines on land and in water, even in strategic sea lanes and waterways, is a classic military tactic to deny access to an area or a region. So since European countries, especially NATO members that are located close to Russia, they fear Russian aggression and a possible Russian invasion, they want to withdraw from Ottawa Convention that basically prohibited anti-personnel mines. Because laying of mines is easy, but once it is laid, eventually after few months and few years, the armed forces will forget as to where exactly the mines were laid. It's not that they'll have exact precise location. In many cases, even after the war has ended, the mines remain over there for decades together. Take Vietnam, for example. Though the war ended, mines continued to explode for many, many more years, killing innocent civilians, injuring people across the world. We have seen this in many conflict zones, in Bosnia, in African countries, where mines laid during a war to deny access to the enemy troops, they will remain there. They're never cleared. They're not removed. Because the ones who laid them, they don't know where exactly it is located. And if they were to try and take it out, there is a risk of explosion. So they don't do it. So mines remain where it is for many years and decades, creating a huge risk for civilians and human rights. That's why Ottawa Convention was brought in place to prohibit and prevent anti-personnel mines from being deployed. So countries which were part of it, they have now withdrawn, especially Finland, Poland, Lithuania, Latvia, and Estonia. The Baltic states that share immediate border with Russia, then Poland as well, and Finland. They all share immediate borders with Russia. So they feel they are next after Ukraine. So they want to lay the mines, prevent any possible Russian invasion, if at all it happens in the future. So they have withdrawn from the Ottawa Convention so that they are not bound by the regulations on anti-personnel mines, which means they are looking to lay the mines across the borders to prevent any possible Russian invasion. So that's why Ottawa Convention is in the news and is very, very important. It was adopted in Oslo in Norway in 97, but signed in Ottawa in Canada and came into force in 1999. But please note down, India, Pakistan, and even China, Russia, US, they are not party to it. Since Pakistan never agreed to sign, India also has not signed it. We want to keep the option of deploying anti-personnel mines. Same with US, China, Russia. So 165 states have ratified it, but these major powers, including India, have not become part of the Ottawa Convention. Now let's talk about a related topic. Let's talk about the Convention on Cluster Munitions, which has also been in the news. Because there have been reports that Russia has deployed cluster munition. There have been reports that US, Israel, and even Iran, all of them have deployed cluster munitions in the recent conflict. So, which country has recently withdrawn from the Convention on Cluster Munitions? Is it Russia or Ukraine or Lithuania or Poland? What's the correct answer? Anyone? Which country has recently withdrawn from this important convention? Very good, Pavan. Option C, Lithuania. Again, the same Baltic state. Lithuania has withdrawn from the Convention on Cluster Munitions. See, cluster munitions, they are usually deployed through a ballistic missile or sometimes even through a cruise missile. And they basically carry multiple warhead clusters. It's a little similar to MIRV or MIRV technology. In case of MIRV, each payload is independently maneuverable. Each of the warhead can be independently maneuvered to a different target, right? In MIRV, in multiple independent re-entry vehicles. But in cluster munition, they are usually not controlled. It's not guided. It's not maneuverable. Once the multiple cluster warheads are released, you have no idea where they will drop or which target they will hit. If you have seen visuals from Iran and Israel, where both sides had deployed cluster munition, one missile will eventually release multiple clusters during the final phase. And these clusters are usually free falling. They glide and they strike a target, and they are usually not guided or controlled. It's not maneuverable. So since it's not maneuverable, it can strike anywhere. It can hit civilian targets. It can hit houses, public spaces where civilians can get killed. That's why using cluster munition is again seen as against international law. There's a dedicated convention for this. Since these are scattering bomblets that are scattered over a large, wide area where civilians and non-combatants could get killed and injured, the usage of such cluster munition is prohibited under the convention. Clear? It was brought out through the Oslo Declaration on Cluster Munitions in 2007, and it has been in force since 2010. However, countries like Russia, China, US, and as well as India, they are not part of it, meaning they want to retain the option of developing and using cluster munitions. Now, Lithuania has withdrawn because it perceives a threat from Russia, and if at all Russia gets aggressive, it wants to retain the right to use cluster munition against Russian invading troops. So this again shows how dangerous the world is becoming. Now, coming to the next important topic, the Vienna Convention on Diplomatic Relations. This has been in the news because recently India, Canada had a diplomatic spat. India, Pakistan also downgraded the diplomatic ties. They sent back some of their diplomats, declaring the diplomats of the other country as PNG, persona non grata. What do you mean by this? Right? What are the rules governing diplomatic ties? Are there any standard protocols followed over here? So, in that context, the Vienna Convention becomes important. The Vienna Convention goes back to 1961, adopted by the United Nations in Vienna, in Austria. It basically lays the standards expected for diplomatic missions and diplomats who are posted in a particular country. So every country is obligated to protect foreign diplomats and foreign missions. For example, India has an international legally binding duty to protect every foreign embassy and consulate that's located in our country. In Delhi, you have Chanakya Puri, where most of the embassies, high commissions are located. Across India, from Mumbai to Kolkata to Chennai to Bengaluru, there are multiple foreign consulates, right? These are diplomatic premises of foreign governments. So they are as good as sovereign territories of that country. There are foreign diplomats working over there. So you can't intimidate them, threaten them, arrest them. They need a certain immunity to operate, what we call as diplomatic immunity. Or else imagine, can you think Indian diplomats being allowed to freely work in a country like Pakistan? Or the other way around. Do you think India would allow Pakistani diplomats to freely work? Never. Countries which are hostile, countries which suspect each other, even if they are best friends, they will spy on each other. They will not allow the diplomats to function properly. And usually, in the name of diplomats, most countries, they try to deploy intelligence operatives. So, to protect the diplomats and give them some leeway to operate, to conduct their official work, they'll have to meet different stakeholders. They'll have to carry out different visits. They'll have to engage in secret classified communication. So, to ensure that diplomats are not threatened, their communication is not intercepted, to ensure diplomatic vehicles and buildings are protected, to ensure the residences of the diplomats and ambassador and high commissioners is protected, you need an international framework, and that is your Vienna Convention. It recognizes how countries can maintain friendly diplomatic ties and lays down a few standards. It establishes how communication channels will be maintained between governments. When it comes to foreign bilateral ties, there are basic standards expected by all the countries, and they have to mandatorily follow these protocols. So, all UN member states are party to it, including India, and it accords diplomatic immunity to foreign diplomats. It gives them protection from arrest. Or else, imagine false cases can be brought up, right? If a foreign government wants to prevent a diplomat from working properly, they can bring false charges, get them arrested, and deport them. So, to protect diplomats in foreign countries, immunity is granted to them. That's why they have different passports, diplomatic passports. The entire premises, right from the embassy and the consulates to the residences to the vehicles as well they travel in, will enjoy diplomatic protection. All these places are as good as the territory of that country. Like Indian embassy in Washington, Indian consulate, let's say in China, they are as good as Indian territory, meaning Chinese police or American officials can't enter the premises. They can't arrest the Indian diplomats. These are the basic protective measures that are provided through Vienna Convention. Diplomatic communication cannot be intercepted. It would be unlawful. It would be illegal. And if any foreign diplomat is working against the security interests of the country, the host country, such diplomats who are basically intelligence operatives, if they are identified by the host state, they can be declared as PNG, persona non grata. Or if diplomatic ties collapse between two countries, they can throw out the diplomats by declaring them as PNG. When they are declared PNG, it means their diplomatic immunity is being revoked. They are on notice. They'll give them a notice of 24 hours, 48 hours. And within that, they have to leave the country. If they don't leave, they will lose the immunity. And if cases are filed, they can get arrested. So that is why Vienna Convention is extremely important. Next, UN Convention Against Corruption. Since global corruption has been in the limelight and UN has been pushing for good governance, for greater transparency and accountability in governance, the UN Convention Against Corruption, though it's an old topic, continues to remain relevant for the exams. It was adopted in 2003 by the UN General Assembly, came into force in 2005, and there are 140 signatories with 190 parties backing the UN Convention Against Corruption. So, India is one of the parties. We have signed and ratified this convention. In 2023, the 20th anniversary was also marked. It basically lays out the standards to tackle corruption within governments. It recommends measures for good governance. For example, it recommends policy standards which can be implemented through a law. India's Prevention of Corruption Act is partly inspired by such global frameworks. It recommends the investigative methods to be followed, how such anti-corruption bodies like Lokpal, how they can remain independent. It mandates that these bodies should be given certain degree of autonomy to investigate government ministers, politicians, government officials, and the bureaucrats to tackle corruption within the system. It promotes the use of technology, especially e-governance, to limit government discretion, to limit the interaction of government officials with the public, and make governance seamless so that there is no scope for asking for a bribe. It talks about improving ease of doing business, reducing licensing and inspection mechanisms, which can be abused and misused by corrupt officers. So it's all about governance reforms and good governance measures. So it's like a guiding light for the world to tackle corruption, and India is part of the UN Convention on Corruption. So now we have come to the last topic for today. We have easily covered more than 30 critical treaties and conventions. The last topic is the Global Pandemic Treaty that was recently adopted by the World Health Organization. Following the experience with COVID-19 pandemic, the world realized how grossly unprepared we are to deal with such a global pandemic situation, right? Imagine if COVID-19 was much more severe. What if it could mutate? What if it could become more transmissible? What if it had a much higher mortality rate? Basically, there are pathogens which have apocalyptic potential. There are pathogens which are so novel that we have never been exposed to them. And it's very critical for the global community to build up the efforts to make our society resilient to deal with such pandemics and epidemics. So, after the lessons learned from COVID 19, WHO pushed for this proposal to have a global pandemic treaty. And finally, the treaty has been adopted. At the World Health Assembly, which is the executive council that manages the WHO, it meets every year and it acts as the highest decision making body for the World Health Organization. So last year at the World Health Assembly in 2025, the Global Pandemic Treaty, also known as the WHO Pandemic Agreement, has been adopted. And India is one of the supporters of the treaty. We are part of the drafting process. We have supported its adoption as well. So there are some key points that you need to note down. Under the Global Pandemic Treaty, it mandates pathogen access and equitable sharing. This is one of the key principles. If you remember, during COVID-19, countries like China, they were very opaque about the initial outbreaks. They did not share much data and information. China didn't even give access to WHO. It did not even share the genomic data of the novel coronavirus. If China had acted responsibly, if WHO had more powers to extract that information, probably the spread of COVID 19 could have been curtailed. So, this was an experience, it was a lesson learned. So, that's why pathogen access is being made mandatory. Across the world, countries are constantly researching about variety of pathogens from bacteria to viruses to fungi, which have epidemic and pandemic potential. So when they come across new variants, it's mandatory right now to share that genomic data, genetic information, and give access to researchers across the world, including pharmaceutical companies, so that they can preempt, they can develop vaccines and drugs even before the disease can break out. So pathogen access is mandatory under this treaty. And in return, countries will get equitable access to vaccines, therapeutics, diagnostics, and drugs. During COVID 19, another problem was underdeveloped countries, small developing nations. They struggled to get hold of diagnostic kits, vaccines, and therapeutic drugs. There was a big divide between the haves and the have nots. So, to plug that gap, equitable sharing is being promoted. So all countries which will be party to it, they have an obligation to give access to the genome data, collaborate in pathogen research, and ensure that the pharma access is provided equitably to benefit small countries and developing underdeveloped nations. It mandates sharing of technology and knowledge transfer. Let's say a country dealt with a local outbreak, and if it has epidemic pandemic potential, sharing that knowledge and information could help other countries to manage it if the outbreak occurs. It creates a financial mechanism to fund greater research into pandemics, into different pathogens, to develop new line of vaccines which could handle multiple pathogens at once. It also establishes a global supply chain, a global logistic network to ensure the smooth flow of active pharmaceutical ingredients, APIs, that are critical for developing drugs and vaccines. It sets up a reliable supply chain and logistics network, a global level supply chain and logistics network. Then it prioritizes research funding, global collaborated research, where governments will contribute, research institutions, private sector will also contribute. Pharma companies, biotech firms will come together to prioritize global research into pathogens. And at the same time, it preserves the sovereignty of nations. Because governments are very sensitive. If they feel that there is external pressure and interference, they'll stop cooperating. So to remove that element of fear, it promises that sovereignty of the countries will not be compromised. For example, WHO will not dictate the quarantine measures or the lockdown measures because this has serious economic and security implications. The governments alone have the sovereign right to decide whether a lockdown should be imposed, whether strict quarantine controls have to be levied. WHO will not interfere. It will only recommend the strategies, it will share the information, but it is finally left to the governments to decide. It will not interfere with the national sovereign rights of the government. So, this is the basic features of the global pandemic treaty, and India is one of the parties. However, the US, which has quit WHO, has created a lot of concern because Donald Trump doesn't believe in multilateralism. He was very critical of WHO during COVID 19. He accused WHO of colluding with China, and he has pulled out US from the World Health Organization. And this strikes a big blow for the efforts of WHO. It weakens the global pandemic treaty if you don't have the biggest power not participating in it. So that's why the topic becomes all the more important. So on this note, I conclude this marathon session. I really hope it was a helpful and useful session. And whatever we have discussed, trust me, there are high chances of these topics coming up in the prelims. Even if, let's say, 3, 4 questions come out of it, it's totally worth your effort because this is the easiest way to cover all these topics. Correct me if I'm wrong. You will not find this information in one single place. It's not that there's a ready book available or one single website or one source that's readily available. So just follow this class, keep the PPT with you, revise it once. Any question from here, I'm sure you'll be able to answer that. If you like the session, do press the like button, share your comments, and don't forget to share this video with other aspirants as well. Don't be selfish. Don't worry, you will clear the exam. Help your friends also clear the exam, right? So share it with others and please subscribe to our channel. That is it. Thanks for watching. Have a good night.